Good afternoon. The Appellate Division First Department is now in session. Welcome, everyone. I will proceed with a call of the calendar. People versus Graham is submitted. Casellas versus Proano. Respondent is now submitted. Appellant Casellas has 5 minutes. K. Ibrahim is submitted. Admiral Insurance versus Joy Contractors. Appellant Admiral Insurance gets 6 minutes and 2 in rebuttal. Joy Contractors gets 6 minutes. Belster 7 versus 7th Park. Appellant 7th Park is allotted 5 minutes and 2 in rebuttal. Belster is assigned 5 minutes. Gordon versus Consolidated Edison. Appellant Cornett is allotted 6 minutes and 2 in rebuttal. Gordon is assigned 6 minutes. People versus Harrison is submitted. McGonigal versus Daner. Appellant gets 7 minutes and 3 in rebuttal. Respondents Daner gets 6 minutes. Medina Diaz, actually the third party action, Seoul, 540 West, Seoul versus New York City. Appellant Seoul gets 5 minutes and 2 in rebuttal. Respondent New York City gets 5 minutes. 2023 Westchester versus Ben Avenue LLC. Appellant Ben Avenue gets 5 minutes and 2 in rebuttal. Westchester gets 5 minutes. People versus Cruz is submitted. Volpe versus Cohen. Appellant Volpe gets 6 minutes and 2 in rebuttal. Respondent Cohen gets 6 minutes. Morales versus 2400 Ryer Avenue. Appellant Morales gets 6 minutes and 2 in rebuttal. 2400 Ryer gets 6 minutes. Solomon versus Diego Beekman Mutual is submitted. People versus Wasim Wahab is submitted. Engelman versus Ruffy. Appellant Engelman gets 6 minutes and 2 in rebuttal. Ruffy gets 6 minutes. Rappaport versus Strategic Financial. Appellant Strategic Financial gets 6 minutes and 2 in rebuttal. Rappaport gets 6 minutes. Nadim V. Gotti, the court has allotted 3 minutes to Appellant Nadim. And respondents Gadid submits. 340673 LLC versus Seneca Insurance is submitted. First case on the calendar is Casella versus Proano.
Good afternoon, Your Honors, and Happy New Year. Brian Isaac, I represent the plaintiff appellant. Given my adversary's illness, I'll try to truncate my argument and be as brief as I can be. I think it's clear from the photographs, from the testimony, and from the evidence that water was transported from the 914 property artificially to the 916 property where the accident occurred. As I read the trial court's opinion on page 9, what the trial court held was that because Ms. Proano, which is the 916 premises owner, was alleged to be negligent for not maintaining her property correctly, the negligence of Amanda's place became an incidental as opposed to a concurrent cause. I don't believe that that correctly states the law, and I believe your decision in Nehemias 41 AD 2nd 719, 1973, it's an old case, but I think it's directly on point, where you said, and I quote, "Plaintiff fell on an outside stairway of defendant's multiple dwelling. There was ample proof that the step was broken and that the defendant had notice of the condition. The issue litigated was whether plaintiff fell because the step was quoted with ice, a condition for which, under the circumstances, the defendant was not responsible, or whether he fell because of a defect in the step. And here's the holding that I'd like you to apply. If two conditions combine to cause an accident, for one of which the defendant is responsible, there is liability, even though the other cause may have been a contributing factor. The fact remains that you can decide this case based on a simple hypothetical. Let me give it to you. If you have no questions, I'll sit down and stop talking."
No, I have a question, Mr. Isaac.
Sure.
Just so you think that the meteorological records suggests that the icicles were hanging from the gutter and dripping were not the proximate cause. That's not as positive. You're saying that it could have been a contributory cause, but nevertheless, we can find in your favor.
Correct. I'm not suggesting that Ms. Proano isn't negligent. I sued her. I think she is negligent. But the fact that she was negligent doesn't mean that another party can't be negligent, because there can be more than one proximate cause of an accident. And as I read the trial court's opinion, it's page 9 of the record, paragraph 4. The trial court essentially said that because Ms. Proano, the accident wouldn't have occurred if Ms. Proano had maintained the premises properly. That means that the negligence of Amanda's place gets eliminated. I don't think that's true. Take the easiest situation. You have a motor vehicle accident where a motorist violates a rule of the road, makes an improper left or right turn, but there's a question of fact as to whether or not the motorist with the right-of-way could have avoided the accident. It can always be said in that circumstance that if the motorist had followed the rule of the road and had not made the turn, the accident wouldn't have occurred. But we know that we can have more than one proximate cause of an accident. And I would simply point out to you that if you look at Ms. Proano's testimony, she said that this was a recurrent problem so bad that she actually made complaints to Amanda Place's managing agent about it occurring 8 to 10 times with nothing happening. She said on 518 of the—
This meaning the improperly maintained gutters?
Yes, it's. I think the way it was explained by the experts is the gutters themselves, because of their proximity to the premises themselves, ended up damming. They use that term ice dam all the time. And what would happen is the ice dam would then create icicles because the water wouldn't flow through the gutters and leaders, and those icicles would drip both onto the roof of the 916 property and directly onto the steps where the accident occurred. And there's a remarkable photograph in here, which I should probably bring to your attention, on page 831 of the record, where this condition was so prevalent that Ms. Proano actually put up a sign, a form sign, which says, "Ice forms in the edge left side." That's precisely where the plaintiff fell. So based upon the evidence in the record and given the trial court's finding, we submit that there's a question of fact.
So that reconciles the expert Pettin's opinion with respect to the icicles dripping and hanging from 914 East into 916 East. And although that may not be supported by the meteorological records, that's something for the jury, you say, because they could have both contributed to it.
Correct. And I would just point out, Judge Acosta, if there are no more questions, I will stop talking.
No, I do have one question. What do you do with your own client's testimony that there was no ice there, there was no water there, and nothing was coming from the party wall when she fell? I mean, how do you reconcile that with your claim?
Well,
your own client said, no, it didn't come from there.
I think there were two issues there, Justice Scarpula. Ms. Proano said that when she left the premises.
No, I'm talking about Ms. Cassell. I mean, I read Ms. Cassella's testimony.
Okay.
Wasn't there, didn't happen, didn't come from that area. So well, how do you get around? She is the only witness to the accident, and she says that.
Well, but she circled the area where she fell on the photographs, which show an ice condition. I'm not saying she necessarily saw it because she might not have seen it. Remember,
she absolutely said it did not come from that area where you are claiming the dripping came from. She testified to it, that there was no dripping there when she fell. She testified.
I don't disagree with that, but just remember, that's why we had the weather expert there. The weather conditions show that between February 3rd and February 5th, not February 6th, there was 7 to 9 inches of snow. She might not have seen it when it occurred because she might not have been there. But there was abundant testimony that this drip did occur. There was testimony from Proano that it occurred regularly. And most importantly, the expert that Justice Acosta was just referring, Mr. Pettin, he said it. And it's on 222, paragraph 32. The weather conditions that occurred between February 3rd and February 5th, not February 6th, this actually happened February 6th, 7:30 in the morning, had caused an ice dam in the gutters and icicles to form from the gutters and leaders of 914. Here's the important part, Justice Scarpula. Water dripping from the icicle will drop onto the porch roof. So she would not see water dripping to the the roof because it's that hut-shaped roof, but then it would come down. So the fact that she didn't see it is understandable based upon the actual meteorological records that were there. I'm not suggesting to you that she said she saw it, but what I'm suggesting to you is that there's certainly a reasonable inference based upon all the expert testimony, based on Ms. Proano's testimony herself, that the ice condition, which was shown in the photograph on the left side of the porch, which she circled and which she felt, which showed the ice, was the remnant of melting and refreezing that occurred prior to the 6th, not on the 6th. Because as we know—
Mr. Isaac, I got a question. When you're saying left to the plaintiff's left, are you talking about when you're looking at 9/16, that's the left you're talking about, the left wall?
Yes, it would be. Hold on.
So when the plaintiff testified that the ice came from the wall to her left, that's looking at the building from the outside, and it's to the left, right? So
no, I think. I'm sorry, Justice Long. I think what I'm referring to when I'm talking about the circling is 822 of the record, and that would be to the left as she's walking out. You see the circle on 822? She's walking out. So from the perspective that you gave, it would be to the right. From her perspective, it's to the left. And that's how it was in the testimony. That's why I'm using it. 822, it's photograph 2 on the bottom, and she circled the icy area, which was the condition at the time.
Okay, thank you. Thank you, Mr. Isaac.
Thank you so much, Your Honors.
Next case is Admiral Insurance versus Joy Contractors.
Good afternoon, Your Honors. Justin Kinney for Plaintiff Appellant, Admiral Insurance Company. The motion court's denial of Admiral's motion to restore was improper because it is undisputed that this action incorrectly was marked disposed.
But even if that were true, Mr. Kinney, what is the live controversy that you seek to have adjudicated? I mean, the matter was, if we say that you're right, you were not included, what is it that you're trying to get restored and for what purposes? Even if the issue was marked, resolved, and disposed of incorrectly.
The live controversy, Your Honor, concerns our client's affirmative claims, particularly for rescission and related relief, based on the alleged misrepresentations made by Admiral's named insured, Joy Contractors, Inc.
And that's not addressed by the global settlement?
No, Your Honor. This case, as indicated in our moving brief, this case was severed from the East 51st Street crane collapse litigation. It was not resolved as part of that global settlement. That, combined with the fact that LGIC was in liquidation at the time, resulted in an incorrect marking of this matter disposed. Admiral's rescission claim remains open. It is based on its named insured's past conduct, and as this court has recognized in the past, when past conduct is at issue, it does present a genuine dispute for declaratory judgment.
Counsel,
yeah, go ahead.
This is Judge Owing. I got a question. So you got someone seeking for your client to play a claim at the moment?
I'm sorry?
Do you have something where your client is being asked to pay for a claim?
Your Honor, claims.
That's just yes or no. That's what Judge Edmund kept asking you.
I understand that, Justice Owing, and I'm not trying to dodge it. It's a little bit nuanced. Counterclaims for coverage were asserted in this litigation.
Correct.
That being said, is anyone calling my client yesterday, the week before to pay on a claim? No, but those claims exist in this litigation. More importantly, those claims have no bearing on whether Admiral's entitled.
So, counsel, let me ask you this next question. What is your prejudice at this moment then of not restore? What's the prejudice if we don't restore the declaratory judgment action? What's your prejudice if we don't restore? If we don't restore it and we agree with Supreme Court, what's your prejudice? What happens?
If in the future we need to seek rescission, we run the risk that someone said we did not, that we waived it because we sat back and didn't do anything. And we're trying to move it forward.
But
in
you
order
didn't
to
set
get a-
back, right? You're moving to restore it. If we were to say no, you covered.
Yeah.
In the event there is a claim made, then you can go ahead and defend against it. But no one is after you for any money. That wasn't covered as part of the global settlement.
Well, but that's not entirely accurate, Your Honor. Defendants Respondents Counsel also happens to represent one of their insurance companies who advised us back in the summer of 2019 that they have subrogation rights and claims, and that if this matter is restored, they intend to pursue them. So we know there are claims out there.
Then why do you want to restore? For them to assert your subrogation, their subrogation rights. I'm not understanding.
Because my client is interested in vindicating its contractual right to rescind. It could not do that at the time by notice. It had to do it by a judicial determination, which is why we instituted this lawsuit in the first place. And unlike a denial of a motion to restore, which is subject to argument as to what that means moving forward, if my client gets a declaration that its policy is rescinded, it has an immediate impact on my client. It no longer has any obligations under the policy. The policy is deemed never to have existed, and therefore bars anyone from making any claim against that policy. That is the complete resolution my client has been seeking since this matter incorrectly was marked disposed in March 2016.
So restoration seeking a potential controversy.
No, it's not a potential controversy, Your Honor. It's
nobody's suing you and nobody's seeking payment or rescission. I mean, you want us to restore for you to establish a principle of law when no one is after you to pay any of the money involving the controversy.
I'm not sure I necessarily agree with that characterization, Your Honor.
No, I'm sure you don't. That's why you made your claim, right?
I'm not asking, I would not, if the matter were restored, we would not ask the court to declare some principle of law. We would ask the court to declare Admiral's actually issued insurance policy to be void ab initio based on misrepresentations made by Admiral's named insured in the summer of 2007.
Okay.
That's an actual controversy, an actual result that will have immediate impact on the parties. And as such, it wouldn't be an advisory opinion.
Oh, hang on a second, counsel. Let me ask you a question. So that you're saying that when you're saying void ab initio, you're saying that your policyholder made misrepresentations in the application, correct? That's essentially the argument, correct?
Yes, Your Honor.
So how is that ever a waiver? You can never waive that argument. I mean, that argument's always, you always got that argument, so that even if it weren't restored, someone makes the argument later on, if you bring a DJ action, oh, you waived it. There's no way you could waive a misrepresentation in a policy application. That goes to the heart of the application itself, so that there can never be a waiver of that at all. I mean, can you understand what I'm saying? I mean, that's like the court giving, allowing somebody to make a misrepresentation and saying that's good enough and that you can waive that. There's no way a court would ever say that. I don't think so. So when you're concerned about a waiver, really not a concern, because you're going at the heart of the application itself. The guy made a misrepresentation of the policy when they entered into the policy.
Justice Owing, I do understand that argument. I appreciate it and like it very much.
Yeah, I have. It's not bad if like it or not. I think that's wrong.
It may be, Mr. Keeney.
No, but
it may be, Mr. Keeney, that you just need to tape this statement by Justice Owing and attach it to the file, right? So let me hear from the other side.
Your Honor, can I just make one comment to Justice Owing's point, please?
Sure, I'll give you.
Thank you very much, Justice Costa. Justice Owing, I have litigated a number of rescission matters, and there's ample case law in New York that a party seeking rescission is not entitled to sit on its rights and must actively be essentially proactively pursue it. So there is a risk to simply sitting back and doing nothing.
Let me respond to that. Those cases that talk about rescissions, they don't talk about act misrepresentations, do they?
Yes, they do, Your Honor.
They talk of, oh, okay.
Okay, thank you, Mr. Kinney. Let me
Thank
hear from respondents.
Thank you, Your Honor. Can you hear me okay?
I can hear you. I can see you now, yes.
Harris Weiner for Clyde & Co. And I just want to make clear, we represent the defendant respondent, so that's not Joy Contractor, which is the named insured and the party on the caption, but we represent the owner respondents and RCG, the defendant
Gotcha.
respondents. Okay.
Gotcha.
And Your Honors, in this case, Justice Edmeade made a ruling after reviewing the motion papers and hearing 2 oral arguments, and she took a look at the entire context of the case, which she's fully familiar with, having dealt with not only this coverage action instituted by Admiral in 2008, but also the underlying global crane collapse litigation. And she determined that there was no active controversy and there was no reason to restore. Counsel for Admiral's entire point, and it's even in his brief and in the record at page 207, is that Admiral would like a complete closure of the crane collapse claims. And I'm quoting from their email, which in our view would require releases from not only the owner entities named and RCG, but their insurers that paid any of the underlying settlements. Those insurers are not parties to this action. They have never been parties to this action. They have never asserted any claims against Admiral for any type of contribution, subrogation, or any other hypothetical claims that Admiral may conjure up. Admiral never asserted claims against them in 2008 when they brought this case, or at any time prior to this case being marked disposed.
So this is Judge Drawing. That essentially means that if we were to agree with the appellant here, we restore the action, they get their declaratory judgment, they get a declaratory judgment in their favor. It can't be effective against the non-party insurance carriers because they're gonna say we were never a party to that. So you got a nice decision on the on paper, but that doesn't, you can't hold us to not, you can't preclude us from suing you then. I mean, this goes, I mean, that's the end of it, right? At that point.
Well, yes, Your Honor, in that obviously a party that is not a party to this matter could not be bound by it.
Yeah.
However, my point and my client's point, the defendant respondents in this case, is that the attempt to restore this action in order to litigate against some non-party has no basis in reality and no basis in the history of this case. If Admiral is concerned with a potential declaratory judgment action as to non-parties, it can bring a declaratory judgment action in 2021, subject to statutes of limitations and anything else, latches or any other doctrines that it should have brought. Again, this is arising out of a crane collapse from over a decade ago and a matter that was marked disposed in 2016. So Admiral's arguments as to non-parties and the potential hypotheticals are really irrelevant because, as Justice Edmeade made abundantly clear, she asked myself, counsel for RCG, on the record, are you currently asserting claims against Admiral for coverage and to contribute to settlements that, again, have been resolved for a number of years? To the best of my knowledge, and I believe counsel for Admiral would agree to this, is that all claims arising out of this crane collapse have been resolved and settled as asserted by, there were dozens and hundreds of claims for property damage, bodily injury, wrongful death. Those have all been resolved. Those have all been paid out. And there is no active matter in which Admiral is facing claims to pay for that. So the idea that Admiral is potentially on the chopping block or subject to some prejudice should this matter not be restored is, quite frankly, just contrary to the record. And Justice Edmeade recognized that.
Thank you, Mr. Weiner.
Thank you, Your Honor. If there's no further questions, I can.
I think we're good.
Thank you.
Let me give Mr. Kinney, I'll give you a minute.
Yes, thank you, Justice Costa. Admiral is not attempting to litigate against a non-party. It's attempting to obtain a dispositive resolution of its own contractual claims. I agree that all the tort claims arising out of the crane collapse were indeed resolved. Admiral's contractual claims were not resolved, and that's undisputed. Admiral should have a right to get a dispositive resolution of those claims. And The Admiral policy doesn't exist solely for the claims arising out of the crane collapse. It's an excess liability policy that could respond to any claim against Joy Contractors, Inc. And because Admiral has good grounds to seek rescission, it should be entitled to pursue that remedy so that it no longer has any obligations under that policy. Thank you, Your Honor.
Thank you. Thank you both.
Thank you, Your Honor.
Belster 7.
Good afternoon, Your Honors. Brian Mazzola of Boyd Richards for the defendant appellant. And so what we have here is a question. There's no disputed fact. It's a relatively straightforward question of whether or not, under a proprietary lease, a holder of unsold shares who's organized as an LLC can have, quote unquote, a family member for purposes of paragraph 38. And it's our belief that the decision below is wrong because the judge held, in the one hand, while he's not saying that a LLC can never have a family member, the conclusion was that for all practical purposes, there are no people who can be connected with an LLC or a corporation, which would affect, under paragraph 38, that LLC's status as a holder of unsold shares. Effectively,
But we don't need to reach the broader issue of whether an LLC can have a family member, right? If we stake the way that we normally decide these cases, if we look at the language of the proprietary lease, we just get to determine whether the proprietary lease defines family. I mean, go ahead.
The proprietary lease, this building was converted pre-1986. And at that time, pre-1986, only individuals could be shareholders other than the sponsor during that carve-out period for the 3 years after the sponsorship. So I don't believe looking at the proprietary lease would give you a definition of family member because the proprietary lease contemplates a natural person. And what Bellstel here is asking, really, and with the court below,
can the proprietary lease, for example, that was submitted to the Attorney General's office, it did not define family, did it?
No, that issue wasn't addressed. It did not.
But it does allow family as per paragraph 38, right, to be a principal of the entity.
Well, for purposes of paragraph 38, it states that a holder of unsold shares or a family member, when they occupy the apartment for personal use, their status as a holder of unsold shares extinguishes. And that is the intent of the paragraph. The intent of the paragraph. It
was Mr. Campanoli, I'm sorry if I mispronounce his name, Mr. Campanoli, he was not identified as a principal in that 27th Amendment that was filed, right?
He was not identified as a principal in the 27th Amendment, but he was identified as a principal in 2 broker-dealer registration statements that were filed with the Attorney General. So he identified himself not only as a principal and a manager, he also identified himself as a CEO of the LLC's corporate member, and he was a shareholder and a CEO of the Benny, which is the corporate member of its parent, Edelverdi. He also was a manager of Bellstel's management arm and an executive. And I think equally as important as the representations that he made to the Attorney General is he asserted control, complete and dominant control over the LLC. And their corporate representative testified that he had decision-making authority over every detail of their real estate portfolio in the United States.
Including occupancy of the apartment, of the unit itself, right?
Oh, absolutely. And before moving in, he renovated this apartment to suit his tastes. So it goes right to
Counsel,
how did he do that? Did he do that pursuant to a lease?
Well, I don't know how he did the renovations. I believe he didn't have to, as a holder of unsold shares, they didn't submit a request for approval or an alteration agreement. They're permitted to make the alterations.
But he didn't do it as a family member of the LLC, right? That's the whole point. I mean, the point is there's nothing preventing you from now moving to amend the proprietary lease to define it accordingly, right? To include family members to be other than natural persons, or right?
I don't think it's that simple. To amend the proprietary lease, you need a supermajority of the building shareholders, and you have Bellstel, which is a shareholder that has a significant holding, would never vote in that favor.
You know, counsel, what you just said brings up a point. You know, they changed the tax laws in 1986. This was all done in 1998. You know, essentially a decade later, 12 years later. I mean, the shareholders approved the sell. So, I mean, you would think that a co-op board, sophisticated, I mean, you would know these things, right? I mean, 10 years later, they changed the law. You want, you know, to have an LLC buy into the co-op, wouldn't that raise board members as concerns with board members as to say, well, maybe we don't want this? And on the flip side of this, how is this individual holding this apartment? Is it by way of just merely occupying it, or is it under a sublease that he got?
Well, to go to your first point, the board did not have approval rights over the sale from the holder of unsold shares who...
Right.
Not the board, the
you
shareholders, though. The
Right.
shareholders, though.
So the board did not have the right to interfere with the sale.
No, I understand that. I'm saying, but the shareholders did, though, right? I know the board doesn't have right, but doesn't the shareholders have a right?
No,
No,
typically...
the LLC is the owner of the unsold shares, right?
Yes.
And they can sell that, and they can dispose of those units and those shares without the approval of anybody, right?
That's correct. That's one of the valuable
Subject to the language of the proprietary lease, however, right?
That's right.
So the question is, if we look at the proprietary lease and we look at the definition in section 38B as to who is a member of a family, how can we go ahead?
38B doesn't define who a family member is. It just states that the holder of unsold shares or a member of his family. And that provision also states that the sponsor can sell to an individual. So when read in the original context, it's referring to natural people, not entities, which came into being obviously after the tax law changed. And so, and there was a second issue that I believe Justice Boyne raised, and that was the use of the apartment. Mr. Campanelli had used the apartment for his personal use. He entered into a lease, I believe, for 2 years.
He entered into a lease. That's okay, counsel. So he entered into a lease. There is a lease there, correct?
Yes.
Okay, so isn't that contrary to the whole provision that you're looking on, relying on, that he's occupying as a family member? He's not occupying let's assume he's a family member. He's not occupying as a family member. He's leasing that apartment. He's actually paying for that apartment. The way you look at that, it means like someone who occupies it pretty much rent free. But this one is he's actually paying for it though. So isn't there a distinction there?
I don't believe so. However, Bellstel...
Okay, so let me, I'm sorry, I don't mean to rush you, but the 27th Amendment is what we're looking at. The 27th Amendment is where Bellstel bought these units, correct?
Yes.
Okay, so that's where I'm saying that the shareholders approved that 27th Amendment.
Correct? The shareholders had no say over the 27th Amendment, nor did the board.
So how did that 27th Amendment get passed then?
The 27th Amendment was not, quote unquote, passed. It was filed by it was
filed with the AG's office.
The AG's office by Bellstel, reflecting a change in the offering plan.
But you didn't identify Mr. Campanelli as a family member, right? You didn't identify him as a principal. He just leased the apartment. He has a 2-year lease. You yourself said, isn't that incompatible with being a family member? Usually, when I have family members living in an apartment in a unit that I own, I don't do it pursuant to a lease, because that doesn't, to me, those two principles are incompatible.
I don't necessarily agree with that statement. I believe just because there is a lease that's internal between Bellstel and one of its corporate members does not affect whether or not he's using it for his
And
own.
one of his corporate members. So that means that he's not a family. Putting aside the issue of whether an LLC can have a natural a person as a family member.
But the conclusion, and I think that if you carry this out, which would essentially be that a corporate entity owning shares as a holder of unsold shares could never extinguish that right by living in the apartment and having, depending on the circumstances, a shareholder, an owner, someone who asserts control over the entity, moving in and using it for their personal use. And that's what happened here, whether it's via lease or whether he had just moved in. The internal dynamics of the company and how it framed that, I think, is irrelevant to this discussion. The relevant portion is that he lived in the apartment for his personal use, and he moved from Miami to New York for business. So it definitely is, and it comes to the heart and intent of that provision. And Your Honor, I know I'm running out of time on this, but there's an alternate argument where I think this is all rendered irrelevant because under Pastina, paragraph 38, as it refers to holders of unsold shares, is void as a matter of law.
Okay, I'll let you. We'll go over Pastina because I don't think Pastina quite applies to the facts of this case. But you're already been on 10 minutes, so let me get to the respondents. I'll let you raise Pastina in your rebuttal.
Sure.
For plaintiff respondent, Bellstel 7 Park Avenue, James Bailey, Rose and Rose. Good afternoon, Your Honors. Your Honor, I will like to jump into the points that Your Honors have raised because I think they're very important. This was a sublease between the holder of the unsold shares and Mr. Campagnoli. Rent was paid. It was, despite the fact that Mr. Campagnoli, was an employee of Bellstel, nonetheless, there was an enforceable agreement where others who had interest in Bellstel could have enforced it against him had such the occasions arisen.
So Mr. Campagnoli's rights are derived from the lease itself.
Yes, Your Honor, from the sublease. I would like to note the sublease extended November 2015 to January 2017. It's about a year and 2 months. He's moved out. There's no claim, there's nothing in the record that he has somehow moved back in. And in fact, the co-op's notification to Bellstel came in April 2017, in fact, after he had moved. And I would also say that as a holder of unsold shares, Bellstel did seek and gain approval of the managing agent for Mr. Campagnoli's sublease, which was in accordance with the rules of the co-op and the lease. So,
I mean, they need permission. Bellstel, as the holder of unsold shares, needs permission to sublease it, but not to sell the shares of the apartment. Correct?
Well, Your Honor, I've only concentrated on subleasing because there isn't a sale before the court.
No, I'm just trying to distinguish between the ability to sublet an apartment and the ability to sell that apartment without interference from the board. Those are two separate situations.
They are, Your Honor.
Okay.
As we have here, a sublet did require the managing agent's approval,
Right,
which Bellstel obtained. So there's no issue that somehow the sublet itself was improper, no claim from the co-op that it was. Now, if I could set it up conceptually to a point that counsel has made. If Bellstel had sublet the apartment, as was its right, with the managing agent's approval, because essentially, broadly, it is an investor, to someone which there could be no dispute was totally unrelated to Bellstel or any of its corporate or business entities, Bellstel would retain its status as a holder of unsold shares, presumably indefinitely. I believe counsel's argument rests on the assumption, principle, what have you, that the extinguishment clause must come into play, but that's not the case. There's nothing in the proprietary lease, no law I'm aware of, nor I believe cited by the co-op, that a holder of unsold shares must be divested of a very important right. So we look at this broadly. What do we have something that this is more closer to? A sublease to someone admittedly entirely unrelated, or, and getting back to the language of 38B, the mischief that language is meant to prevent is a sponsor allowing, subletting, what have you, a family member to live in the apartment, thereby or selling. One of the problems could be thereby the sponsor exerts indirect control over the co-op. It's not a situation here. Or maybe the sponsor just wants to both have his primary residence at the same time and enjoy the status of a holder of unsold shares, which, at least in this particular context, has a different purpose and a different requirement. This is much more like an unrelated, a sublease to an entirely unrelated party. And there's nothing in the record, nor I believe any claim, that any harm has been done to the co-op. I would also like to briefly add, and it is cited on my brief at, I believe, page 20, Bellstel is a minority shareholder. As Your Honor said, if the co-op wanted to change the rules, they have every right to. Paragraph 6 of the proprietary lease is upon 75% vote of the shareholders, it can be changed. So I believe the court in this situation did properly interpret the plain language of the lease and found that the phrase family member does not apply to Mr. Campagnoli, and the court could not find, as it said, a principled, practical way of defining who would be a family member in relation to an LLC. The co-op can change that.
But we don't need to get there, right? And that was the point that I started with. We don't need to deal with the broad principle as to whether an LLC can have a natural person as a family member. We don't need to decide that issue to decide the specific matter that's before us now, namely the status of Mr. Campagnoli.
I do believe the court could properly decide that way. He's a tenant. First and foremost, or subtenant, because there is a sublease. He's
a tenant, but he's not a family member. I mean, he's a tenant pursuant to a sublease with a duration of time. So if there's any interest in having that issue, or whether an LLC can have a natural person as a family member, that's an issue that can be simply address if it were in the context of amending or amending paragraph 38, which can be done by section 6 and a vote of 75% of the shareholders, right? That is correct. To decide that issue. So we don't need to get into, usually when we interpret these relationships and these definitions, one of the documents that we concentrate on are the proprietary document, the proprietary lease, the bylaws, etc. Where are these things defined? We don't need to go into this ethereal, area where we need to decide issues as to who constitutes a family member, can a corporation have one or not. Why do we need to decide that issue when the facts of these cases are very clear?
Your Honor, that is correct. Yes, the court can, of course, on narrow grounds. I'm not pressing the I believe the broad grounds would fly, but obviously the court wants to define things on narrow grounds. You don't have a bona fide family member as a bona fide occupant in any permanent or relevant sense to paragraph 38B, which envisions, as I said, mischief that just doesn't arise in this case. And Your Honors, if I may address the Business Corporation Law 501C
I'll give
argument.
you 30 seconds.
Okay. It was not preserved for review. Well, as admitted, I don't think this is the case the court wants to decide that issue on. I don't think the court should find it. Tiemann cited in my brief, I think, gives the answer. A holder of unsold shares is a different class. But the court wants a full record before it decides that issue, not brought up here on an appeal.
I got it.
Thank you, Your Honor.
Mr. Mazzola, I'll give you a minute.
So just very quickly, Your Honors, this is not an arm's length transaction, and Mr. Campagnoli is not a simple employee of the company as they tried to allege. What we showed and what the record clearly shows is he dominated this corporation, had ultimate decision-making authority. So to argue that because he signed a sublease, which is illusory between
but we don't need to dispute that, because the facts are, admittedly, and I don't see you refuting them, that he occupied the apartment pursuant to a sublease, a 2-year sublease, right?
Yeah.
So that sublease is what determines his rights.
Well,
as an occupant of that apartment, no?
I don't agree, and I don't want to belabor the point because of my time running out, because I do want to address Pastina, and this is squarely on point with Pastina. And what we have here is not a sponsor who under Susser is afforded special rights and a de facto separate class, because a sponsor has additional rights and responsibilities under the offering plan. But what we have here, and which is different from TM and some of the other cases that plaintiff has relied upon, is that Bellstell specifically, specifically said in the offering plan that it was not taking on any additional responsibilities, that it was not fulfilling the sponsor's duties, and it was in fact not fulfilling any responsibilities of any prior owner.
I mean, the issue, let me say that the issue of Pastina, you only raised in appeal, right? You didn't raise that before before the trial court, right?
That's correct, but it's a matter of law. There's no additional facts that are necessary. It's very simple as a matter of
so it's a pure legal issue. Okay, I buy that. So the question is, how isn't Pastina distinguishable, because he dealt with paragraph 38 relating to privileges granted to original purchasers rather than subsequent holders of unsold shares?
No, Pastina, the issue in Pastina was whether or not someone was a holder of unsold shares. If he was if Bellstell was the original sponsor, I think there's a different argument. And I'm not sure that I would argue that paragraph 38 is void. We are talking about Bellstell, which is not an original purchaser, which is not a sponsor, which does not have the sponsor's obligation. So I think Pastina is squarely on point and states that the special rights afforded under paragraph 38 are void because they're being treated as a different class of stock under 501c, and it violates it as a matter of public policy.
Okay.
So
I got that. Thank you, Mr. Mazzola. Thank you, Mr. Bailey. Great argument.
Your Honors, thank you very much. Good day and Happy New Year.
You got it. Same to you. Gordon versus Conet.
Thank you, Your Honors. This is Adam Smiley, counsel for defendant appellant Consolidated Edison. Plaintiff insists that she lawfully used medical marijuana on December 17th, 2016. This is unequivocally false. She did not take the first step towards certification until December 27th, 6 days after her drug test. Plaintiff cannot use any purported disability as a shield against misconduct. Con Edison terminated plaintiff because she used marijuana, violation of the drug testing policy, and not because of any disability. And I'd like to focus on two errors made by the motion court in denying Con Edison's motion for summary judgment. First, the court improperly found a triable issue of fact regarding pretext. And second, the court failed to identify that an accommodation request to excuse misconduct is unreasonable as a matter of law. I'll begin with pretext. First, the motion court ignored the overwhelming and undisputed evidence that Con Edison accommodated other employees who were medical marijuana patients.
Were any of those probationary employees?
I believe. Actually, I'm not 100% sure.
Yeah, because I thought they were all permanent employees. Is what the record reveals. So, are you treating her differently because she's a probationary employee? And is there such a thing? Is there a probationary employee defense to Con Edison with respect to accommodating her?
Sure. I'll say this. If a probationary employee has a valid certification for medical marijuana, they will be accommodated. We are obliged by the Compassionate Care Act.
But the record doesn't seem to suggest that everyone who you have accommodated is a permanent employee.
Again, that was during the relevant time period. I believe, subsequently we just didn't have at that time. Again, the law was passed much more recently at that time. We did not have any probationary employees. But certainly if a probationary employee has a valid certificate, they will be accommodated. The issue with the short tenure, the probationary period, is if you violate the drug testing policy in your probationary period, that's when you're terminated. And that's what plaintiff did here.
Okay.
And again, I think so that is critical and undisputed evidence. We acknowledge that the policy of terminating somebody within their first 6 months is not a formal written policy, but the undisputed facts show that this is our practice without deviation. During the relevant time period, Con Edison terminated each of the 14 employees, including plaintiff, who tested positive for drugs during their first 6 months on the job. Plaintiff wasn't treated unfairly.
Had any of them been certified by the state as marijuana users?
Absolutely not. If somebody was certified, then it wouldn't have been misconduct. It would have been acceptable use of a prescription medication. So the answer is
did any of them, counsel, this is Judge Scarpula, did any of them come to you and say, I have an illness for which medical marijuana has been recommended to me and I am in the process right as we speak of doing this? Did any one of them that you fired say anything like that, the way that we have in this case? I mean, there's no doubt this woman came to you and said, I'm in the process of getting my certification, right? And you fired her anyway. You knew before you fired her that she was in the process of getting her certification because she told you that, correct?
Yes.
In fact, she had gotten the certification before you fired her.
Absolutely, we acknowledge that. I think the critical thing here is when plaintiff used marijuana and when she took her drug test on December 21st, she had yet to take any action to get certification. She committed misconduct, and only after her drug test came back positive did she then seek certification. We agree she sought certification and she eventually got it, but she can't use that as an excuse to condone her misconduct, which we believe is clear and undisputed.
But doesn't that get to the issue of pretext? I mean, the problem is that you want us to find no pretext without any discovery, without eliciting information with respect to how you've treated other employees, whether they've been permanent or probationary, whether you in fact dismissed her because you could and you don't have a collective bargaining agreement with respect to probationary employee. So there are a lot of issues here. The problem, I'm not saying that you wouldn't prevail. If this were a summary judgment motion after discovery, we will be in a totally different posture, right?
Your Honor, this is a summary judgment motion, if I may. This was a denial of summary judgment.
Oh, I'm sorry. I thought this had been a dismissal motion.
No, and to get to your point, Your Honor, we feel like we put on substantial evidence that there was no pretext. Again, every single person who violated the drug policy in their first 6 months was terminated.
Wait
and
a second. Every single person have that card 3 minutes after the drug test, or a couple of days after the drug test? Are you saying I mean, there's no doubt this is what this woman was doing. It's not that she had the illness. She went to get the card. She got the card, and it's not like she waited 6 months or 6 years or 10 years. It was literally within a month. And you're saying that was a reasonable accommodation, that you're entitled to stand on, there's no doubt she has the disability. There's no doubt that she sought the medical marijuana for the disability. And you're saying your reasonable accommodation was not to consider any of that, but just fire her because she was a probationary employee?
No, Your Honor. The reason why she was—
That's what it sounds like.
No.
It sounds like there was no accommodation at all. There was no attempt to accommodate.
Your Honor,
it sounds like your opinion was, she's probationary. We can fire her for any or no reason. Let's just do it.
Your Honor, respectfully, the only possible accommodation that she asked for or could seek here was for Con Edison to excuse her misconduct. It's undisputed. She had no lawful right under the Compassionate Care Act to use marijuana on December 17th.
What was,
So,
did you
Counsel-
engage? Yeah, go ahead. I'm sorry, Justice Weber.
Go ahead, go ahead.
No, you go.
What I'm trying to understand is, Counselor, there is a distinction between her disability, which is the IBD, and her use of the marijuana. So the use of the marijuana was in efforts to treat the IBD, but you fired her apparently because of her quote unquote violation of the drug policy. But the violation of the drug policy appears to be her seeking the accommodation for her disability, which is the IBD. So we're kind of going around in circles a little bit, and that's the point. The point is that there has to be some determination as to exactly, was there a pretext or was there not a pretext?
Absolutely, Your Honor. To address that, a couple things. First of all, that's not what the complaint actually alleges. The complaint alleges she was terminated for her use of medical marijuana, and the motion court judge in footnote 1 on page 7 properly noted the focus of this case is the medical marijuana status, not the underlying IBD. That being said, during her deposition, plaintiff admitted that her IBD was in remission. She admitted that IBD did not impact her ability to perform her essential job functions. She admitted her performance was exemplary and admitted that she didn't need an accommodation. On those undisputed facts, there was no accommodation even requested. She can't make out a prima facie case. So to your point about IBD, we think we're entitled to summary judgment on that. But to go back to the medical marijuana.
Were you required to engage her in a interactive process?
Well, our view is that we first of all did, but I'll say this: when plaintiff committed misconduct, the Compassionate Care Act was very clear. If plaintiff's theory is accepted, what we're saying is that anybody can self-medicate and use recreational marijuana, even as for.
No, but those are not the facts of this case. I mean, she talked to her father, who told her that this would be a way to relieve her horrible physical conditions, gastrointestinal issues. She does it. It works instantaneously. Those are the facts of this. It works instantaneously. She therefore begins the process immediately to get certification. Of course, when she did try it upon her father's recommendation, within a few days, before she got the certification, we get that. The question is, are you required to engage her in some sort of process? You think you did? Why do you think that?
Well, I think, Your Honor, I just want to make clear the Compassionate Care Act lays out very specific requirements to apply for medical marijuana use.
Hello?
So even if plaintiff talked to her father, even if she talked to her primary care physician, her primary care physician was not licensed by the state to authorize it. She didn't follow the procedure. That being said, our view is—
But that's only with respect to the state law, right? With respect to the city human rights law, clearly she has a physical condition, right? She has a condition that affects a system of the body. Clearly she has a disability. The question is, are you required to accommodate that disability? That all depends on the individualized interactive process that you engage her with. That's why I asked you before what that process was.
And Your Honor, so to the IBD, we feel that based on the undisputed facts, she wasn't impaired. She fully admits it had no impact on her ability. Regarding the marijuana, our view was that plaintiff committed terminable misconduct.
So you're saying that she doesn't have a condition that has impacted a system of her body, right? You disputing that she has IBD?
No, we don't dispute that. But our view is that this case is about the medical marijuana status. And in her own words, she didn't need an accommodation. She said my performance was exemplary. She says IBD didn't impact my ability to perform an essential job function. She has to need
But Counselor, in your motion for summary judgment, you do argue that there was no disability to accommodate. So to Justice Acosta's point, you are stating that she did not have a disability.
Your Honor, I think we argued both the IBD and the medical marijuana. It was a bit unclear. We are arguing that her status as a medical marijuana patient does not give rise alone to an interactive discussion because she was not a medical marijuana patient when she committed misconduct. And I think Hazen v. Hills, Betts and Nash is a First Department case directly on point. If an employee commits misconduct, they cannot use a disability as a shield. A company can terminate an employee for misconduct even if they have a disability. And what plaintiff is saying that you can't fire me even if I committed misconduct because I have the disability, and that is incorrect as a matter of law. And that's all. The only accommodation plaintiff seeks, in her own words, is for us to ignore her misconduct and allow her to keep her job. And that is facially unreasonable under Hill v. Hazen, Betts and Nash.
Okay. Thank you, Mr. Smiley. Let me hear from the other side.
Thank you, Your Honor. Dan Kaiser for the plaintiff respondent. I just want to underscore a couple of points from the discussion that was just had. First, to be clear, she received her medical marijuana certification days prior to her termination. They knew that. All of that is undisputed. They had information that she was a certified user, and then they made the decision. In the weeks prior to that decision,
what do you think? What do you think that he should have done? What do you think Connett should have done?
Well, they should have permitted her to remain employed and be a medical marijuana user because she had a certification to use that marijuana to treat her underlying medical condition.
And what do you do with what they claim was misconduct, namely the consumption of marijuana prior to obtaining the certification?
The facts here are that she spoke with her doctor, as per, again, undisputed, about using marijuana to alleviate the most severe symptoms of her IBD, again, undisputed that she suffered from that medical condition. And so the single instance of using marijuana here was to undisputedly to treat those severe symptoms of her IBD, and then began the process of actually getting certification. So to swallow the rule.
But Counselor, did she notify her employer that she was using the medical marijuana in order to alleviate the symptoms of the IBD? And or did she notify her employer that she was seeking certification? And or did she notify her employer prior to the actual testing that she had actually used marijuana?
Well, she didn't affirmatively tell her employer that she had taken marijuana on smoked marijuana on December 17th. But to answer your other questions, they're yes, yes, and yes. She, prior to her termination, in repeated emails that are part of the record, told them that she was in the process of getting her medical marijuana certification card.
Prior to the actual test, prior to the test, wherein the client claims that she committed misconduct.
Yeah. Prior to the test, she didn't tell him that that last night I smoked marijuana to alleviate my medical symptoms. That's true. But in the entire period of time prior to her actual termination, when they were aware that she had used marijuana inconsistent with her doctor's recommendation to treat her IBD, she told them that she was doing that to treat her IBD and told them that she was in process of getting her medical certification. And they had not made a decision.
At all times, they were aware of the fact that she suffered from IBD. Is that correct?
And at all times, they were aware that she suffered from IBD, and that's not disputed either. And they were at all times aware that she was using both marijuana to treat her IBD, as well as that she was in process of getting her medical certification card. And even if it was true,
Mr. Kaiser,
yes, Your Honor.
This is Judge Acosta. So, I know that we're spending a lot of time with respect to the certification process not having been completed, but that only pertains to the state human rights law claim, right? The city human rights law claim doesn't require certification of any kind. The question is whether she had an impairment or she had a condition that impacted a system of the body. And that's not in dispute, is it?
That is not in dispute, Your Honor, that she was disabled as per both the New York State and New York City law. And it is not in dispute that she was trying to use marijuana at the direction of her doctor to treat it. And it's not in dispute that prior to the decision to fire her, she was in the process of getting her certification card. And it is not in dispute that she actually received her card and that they had awareness and knowledge that she had received her card prior to the termination. And even if it were the case that they could terminate her in this context on these facts for her quote unquote misconduct, if that's how they would want to describe it, her use of medical marijuana, that would raise a fact issue for a jury's consideration. I mean, they could make that argument, but the facts are such that they did not make a decision to fire her in those weeks where she had advised them she was in the process of getting her card when she had failed the test. They only fired her, and they only made the decision to fire her within days of them receiving express notice that she was a certified user. So the question becomes, did they fire her for this misconduct using medical marijuana before she was technically a user, a certified user, or did they fire her because they couldn't do anything about her?
Mr. Kaiser, this is Judge Oren,
Yeah.
and I just have a very simple question. What's her role? What's her job at Con Ed? She's a financial analyst, correct? Right?
That's correct.
And the other thing is, this is not a situation where this was repeated use of marijuana that was happening, right? This is a one-time. She tried it because she had to relieve her pain, and that's that. This is not a habitual marijuana user who finally decided to get a certification because she thought it was a good idea to do that after using it for several years, correct? I mean, I would just want to make the record clear as to who we're dealing with.
That's correct on both counts, Your Honor. In fact, the occupational therapist who they sent her to see after the drug test acknowledged to her, well, you know, your marijuana use in this context has nothing to do with your job. It doesn't present a safety issue. There's zero. She didn't use it when she was working. They don't contend she used it when she was working.
In a sense,
all of that is established.
In a sense, the termination is kind of harsh when there was something. I mean, this record kind of cries out that the termination was a real severe type of employment decision. I mean, it's not like we're dealing with some sort of drug abuser here. That's what this record's crying out, right?
That's absolutely right, Your Honor.
Okay.
There was no evidence of that of any kind. And if they want to make a misconduct argument in this context, they can do that. But it raises all sorts of, as Your Honor said, about what really motivated the termination. Was it pretext? She had her card before she was fired. She was only fired after she received the card, and they had notice of that. Were they concerned about her using marijuana going forward or not? And they did, as counsel noted, they have a written policy that permits, or at least on paper, the accommodation of recreational users, much less medical marijuana users, and that she wasn't given the benefit of that. And there's nothing in that policy that carves out probationary employees. They claim in defense of this case there was conclusory testimony that yes, she was a probationary employee, and that's why we didn't give her a break or didn't permit her to take advantage of this written policy. But she was a medical marijuana user. I mean, if anyone was entitled to a break and to be treated with some Rahmanis, as the suggestion goes, I mean, it would be her. I mean, she was using it to treat her IBD.
Yeah.
There's no doubt about that. Yeah.
Thank you,
Yeah.
Mr. Kaiser. Mr. Smiley, you get a couple of minutes.
Mr. Smiley, is what your adversary just stated correct concerning your policy as to recreational marijuana and probationary employees? Is it that at the time you did not have that policy, but you now do have that policy concerning they're not being terminated, although they're probationary and they use recreational marijuana?
No, that has been the policy during the entire relevant time period, and presently, I'm quite frankly not sure what he's arguing.
That doesn't seem to help you with that argument.
Maybe I misunderstood his argument. I was writing my final.
He said that the policy was that even for probationary employees, if they use recreational marijuana, they would not be terminated.
I'm sorry. Absolutely not. Absolutely not. If you're a probationary employee and you test positive for any illegal a substance or use it in violation of a prescription, you will be fired. That was,
But if you're a permanent employee, you will not be fired. Is that correct?
well, there are some circumstances where it's a severe enough safety issue, maybe, but you will typically given several chances through counseling.
Mr. Smiley, see, that's my concern there. This employee or this former employee, there's no safety concern as to her job description, right? She's not in the field, correct?
No.
So that the way I look at it, you do give accommodation to folks who have been certified marijuana user for medical purposes, who are permanent employees, and you allow them to continue that. So we're talking about a very sort of fuzzy line here, so that, you know, she was on 6 months probation, but what if she was on the 6 month and a day later, and then you do the drug test, and a day later, you found out that she's been using marijuana, and then, you know, you see what I'm saying? I mean, it's kind of like, you know, you open the door to others. You have a situation here that she's got the certification of use. Okay, maybe she didn't get it before the drug test, but she did get the certification at some point.
But she did agree. But interestingly, Justice Owen, and maybe you want to answer this, Mr. Smiley, the fact is that she began the certification process before she tested positive at work, correct?
That is incorrect, Your Honor. And that I want to make sure, she used drugs on the 17th. Her drug test was on the 21st. It wasn't until December 27th, 6 days after her drug test, that she sought certification. And I think importantly, not once during those 6 days did she ever tell anybody, I use medical marijuana for an underlying medical condition. The only time she said that was after she tested positive. And I'll point out, her specimen was a dilute net positive. You know.
Yeah, but wait a second, Mr. Smiley, but she did at the point when she knew when she tested positive for the drug, for the marijuana, she's telling everybody, look, I'm in the process of getting certified. Even up until before termination, she says, by the way, I just been certified to use marijuana for medical purposes. And you still, I mean, this is before the termination, that putting everything aside, forget she didn't tell anybody, she didn't do it. But the point of it is that in this, unless I'm totally looking at the wrong record, before termination, she got certified to use marijuana medically.
Right.
And she only used marijuana once, correct?
Yes, if I may, I'm sorry, sir.
Yeah, but did she try marijuana on December 17th, right?
Correct.
And it was the next day that she contacted a physician registered with the New York State Department of Health medical marijuana program.
No,
so this is before the 21st.
No, sir, it was 10 days later. It was the 27th of December she first contacted, 10 days after her use of the 17th.
But the question.
No, that's when she saw. No. On December 27th is when she saw the doctor that she saw. The day after she consumed marijuana, she started a process. She went on the internet, then contacted this doctor who obviously could not see her instantaneously. He only saw her on December 27th. But she has started a process way before she tested positive on the 21st, right?
You're right, Honor. I think that the critical point in my view is this. She may be a sympathetic plaintiff. She may have used it for sympathetic reasons. I understand that. But what we're doing is acting as a personnel department and evaluating the right and the decisions made by Con Edison, whether it was too harsh or too light. That's not the role of the court. I think it's undisputed, even if you think her use was sympathetic, when she used marijuana, she had no lawful right to use it.
It's not about being sympathetic. It's a question of how do we apply the law in this case. In the instance, I mean, for example, you raise the Haitian decisions and cases like that involving misconduct. But I find these cases to be totally distinguishable from this instant case, because the misconduct that we're talking about was not caused by the actual disability. So that's how those cases are distinguishable from this case. But we've been at it for another 5 minutes in rebuttal, so it's time to move on. Thank you very much, Mr. Smiley. Thank you, Mr. Kaiser. We go on to the next.
Thank you, Your Honors.
Your Honor, appreciate it.
Okay. So that's McGonigal.
Yes.
Okay, let me hear from Appellant.
Thank you. Good afternoon, Your Honors. I'm Annette Hasapidas, appearing for the plaintiff in this case. Respectfully, the lower court erred in granting summary judgment to Dr. Diener, the anesthesiologist, during the surgical procedure at issue. I'd like to point out that it's undisputed here that defendant proffered the neurosurgeon's deposition testimony in support of summary judgment. And that neurosurgeon reached 3 opinions at his deposition. At pages 952 and 953 of the record, he opined that plaintiff's vision loss was not caused by trauma. He further opined that it was not caused by compression, and that the etiology of the vision loss was ischemic in nature. What does the defendant do with these 3 opinions? She doesn't address them. Dr. Bloom, defendant's expert, says that Dr. Peterson hypothesized that hypotension could have caused the vision loss. He doesn't address the 3 opinions by Dr. Peterson. Defendant, in the brief on appeal, acknowledges that this is Dr. Peterson's opinion, and at page 11 says it's a faulty opinion, and that Dr. Bloom's disagreement with Dr. Peterson's opinion doesn't mean that Dr. Bloom's opinion is insufficient. Well, Dr. Bloom's opinion is evidence, but it's directly in conflict with Dr. Peterson's opinion. Dr. Bloom does not square his opinion with Dr. Peterson's opinions that this was an ischemic vision loss, and as a result of that, the defendant never.
But what do you do with the post-surgical imaging, which shows the absence of an ischemic event?
Well, Dr. Bloom never explains what would have shown up on imaging. What we're talking about here is, and I would point out specifically.
But I thought Dr. Bloom did do that. I mean, Dr. Bloom opined that the plaintiff's post-surgical loss of vision was not caused by an ischemic event. He specifically finds that.
That's right. And Dr. Peterson, who according to his office records performed an extensive post-surgical workup, concluded that it was an ischemic event. And so the court doesn't.
But the imaging doesn't show it, though. It does show some bruising in the orbital.
Correct.
So I mean, what do we do with that?
I would submit, Your Honor, that the court should conclude that the neurosurgeon's opinion is in direct conflict with Dr. Bloom's opinion. Defendant was obligated to explain how Dr.
No, but it's in direct contradiction to the actual imaging that shows no ischemic event. You don't dispute the record, right? I mean, the imaging that was taken, the post-surgery, shows no ischemic event. It shows some bruising in the orbital rim, but it doesn't show anything else.
I understand that. He doesn't explain what would be shown on the imaging to evidence an ischemic event, which would allow the court or the plaintiff even to refute the opinion. And Dr. Peterson reviewed the same MRIs and reached a contrary opinion. And the defendant cannot complain that there's a conflicting opinion testimony because the defendant adopts Dr. Rucker's opinion. Dr. Rucker was a neuro-ophthalmologist who said it was non-ischemic. And our point here is not that we're entitled to summary judgment, but that no one is entitled to summary judgment because there are clear conflicts here. The defendant doesn't address it. And I would next point out that there was the most extended period of hypotension was from 10:30 until 11:25. Dr. Bloom nowhere addresses that whether or not this was a departure. If the court looks at page 47, paragraph 30, Dr. Bloom glosses right over this 1 hour period of hypotension. He never says that it wasn't a departure. He says throughout the surgery, Dr. Diener evaluated McGonigal's map as it fluctuated, and at 11:25, she administered a single dose of ephedrine, a vasopressor. He nowhere says.
I thought that he says that or his opinion was that the plaintiff's allegation regarding intraoperative monitoring was based on a false premise, that there is a specific blood pressure range which is appropriate. He says instead that a patient should be monitored for hemodynamic stability through a number of vitals, not just blood pressure, but a bunch of other
Agreed. And if you look at pages 1254 and 1256 of the record, it shows that her blood pressure fell below the range that Dr. Diener had selected for an extended period of time for almost 1 hour. And Dr. Bloom never says that it was not a departure to fail to treat this 1 hour period. This is not transient. Our own expert said.
Well, it wasn't really an hour, right? It was first from 9:11 to 9:20 and then 10:30 to 11:25, right, according to the record at 2:14.
Correct, Your Honor. I'm focusing on the 10:30 to the 11:25 because that's the longest period here. Right. And our expert even pointed out that it is a departure for an anesthesiologist to pick a range, and then when the blood pressure, when the MAP reaches the same low levels, to choose to treat it, not to treat it in one instance and to treat it in another. She didn't choose to treat it from 10:30 till 11:25, but she chose to treat it at 12:25. And we're simply asking for a trial before a jury because of the disputed expert issues. And before I yield, I just want to say one more point, is that the defendant has acknowledged that they did not make out a prima facie case or prove within a reasonable degree of medical certainty the cause of the injury. They maintain they did not have to. So the only issue here I would submit is whether there's a departure. I'll reserve my time for rebuttal. Thank you, Your Honor.
Thank you, Ms. Azapides. Okay, let me hear from the respondent.
Good afternoon, Your Honors. I am Judy Shalmetzi with Wilson Elster for the respondent. Let me start with the plaintiff's point about the neurosurgeon's opinion, and I would like to correct the terminology because I do think it matters. It was the neurosurgeon comes to see the patient in the hospital. His patient basically looks at the patient and says, "I didn't do it during surgery. Anesthesia must have done it. This is an ischemic event in nature." The important part here, this isn't an opinion that the plaintiff submits in support of her summary judgment, as we use that terminology. This is, in that moment, that treating physician's diagnosis. I don't represent that treating physician, and I don't want to do what he did when he says it was anesthesia. But it is possible that as he's standing there looking at her, he thinks, I think it was ischemic. Just like other people for a little while thought that it was an ischemic injury and then realized that her course is actually incompatible with that because she's improving too much. And that if it had been an ischemic injury, that would not happen. So the fact that you have a treating physician's note in the chart that says, yeah, I don't think it happened during the surgery, I think this is ischemic, is not the equivalent of having an expert opinion in the terms that we've been talking about, where you have expert opinions.
Is the belief that it was an ischemic event inconsistent with the post-surgery imaging that was taken that reveals no ischemic event?
So right, so that those are incompatible positions. The surgeon was not asked before he put that note in the chart, or really extensively at his deposition, to reconcile his opinion with the post-operative imaging, and he didn't have to do that, and that was not his burden. That is the plaintiff's expert's burden, who is rendering what we call an opinion in opposition to the summary judgment motion, and what he is required to respond to is very specific. The defendant's expert says that there would have been ganglionium enhancement and that there would have been restricted diffusion. These are two specific radiological findings, which I admit I personally would not be able to look at an MRI and tell Your Honors what that looks like, but those are medical terms that to an expert mean something.
This is Judge Scarpula, and you're saying that the actual documents of that woman dispute or show that the plaintiff's expert opinion couldn't be correct. Correct? Is that what you're saying? Because
that is correct.
Showed on the MRI and it didn't.
That is correct. Our expert's opinion is the MRI result, the absence of certain findings on the MRI result, where those findings would be present had this been an ischemic event. The absence of those findings, our expert opines, conclusively establishes that this was not an ischemic event. That is the defendant's position. That is why this is not a pion. Plus, she's getting better. Plus, it doesn't seem like it's compatible with the literature. Those are smaller things, but the conclusive thing is that it's simply incompatible with the MRI. Very quickly, I do want to reach this argument that if you're going to give medication the second time, then you should have given it the first time. So first of all, it is the plaintiff's own position in that it is on page 4 of her appeal brief and setting up the whole thing that the plaintiff's baseline, the patient's baseline for what her acceptable blood pressure is 50 to 150. And on top of that, you get auto-regulation. So she's basically good 50 to 150. You get into trouble when you hit the 50 and you go under. But as the defendant's expert explains, as the defendant herself explained at her deposition, and as the plaintiff's expert did not address at all, you actually have a wider bandwidth than that because you get auto-regulation on top of that, where you can get low blood pressure, but it's not going to damage you, is basically what that does. For a little while, there's a cushion where the body can make sure that doesn't happen. That's auto-regulation, easy enough. So you have this cushion, and the anesthesiologist says the first time that you reach the 50, she says, okay, but I'm about to give 4 scalp blocks, and I know it's going to shoot up, and it does, and that's why she doesn't do anything. The second time, it goes back up on its own. And the third time she says, you know, it hasn't crossed the 50 yet, but I'm not going to wait it out. She uses her medical judgment to say, I'm not going to wait it out this time. But the fact that on the third instance of that, she exercises the medical judgment to give medication and correct before you hit the 50 does not mean that the prior occasions were a departure. It doesn't work that way. That's what medical judgment is, that in one instance, in the first instance, you say, I know this is going to change. The second time you see it changes on its own. The third time you say, you know what, I've got a trend. I'm not going there. I'm going to give her some meds. Plus, we're near the end, too. So that I think is the counterpoint to make to this attempt to make out basically a self-fulfilling or some kind of proof by a different exercise, a different decision of medical judgment on the third instance. Unless your honors have any further questions, I will rest on my brief.
I think we're good. Thank you so
Thank you,
much. You'll get 2 minutes rebuttal.
Yeah, yes, Your Honor, thank you. Okay, well, counsel has incorrectly represented the record. She's indicated that Dr. Peterson's opinion was made at the bedside and that there was no real expert opinions ever proffered. It's actually the opposite. Dr. Peterson's note shortly after the surgery at page 1496 says that the PION was suspected at that point in time. At his deposition during this litigation at page 952, he is asked to opine within a reasonable degree of medical certainty as to whether it was caused by trauma. He said no. Within a reasonable degree of medical certainty whether or not it was caused by compression, he said no. And within a reasonable degree of medical certainty whether it was caused by an ischemic event, and he said yes. So this is not a situation of Dr. Peterson going in post-operatively and saying, yeah, I think it's PION, and then subsequently offering a watered-down opinion. It's the opposite. So with all due respect to counsel, that's incorrect. It isn't a note in the chart. It was sworn testimony within a reasonable degree of medical certainty. Also, counsel has given this great explanation about auto-regulation of blood pressure and everything else with respect to the second event, the 55 minutes of hypotension. Well, that's great, but that is nowhere reflected in Dr. Bloom's affidavit. Dr. Bloom never said any of the things that the counsel has said, and perhaps
well, Dr. Bloom did talk about the fact that it's not necessarily the number. We're talking about 50, but he said that it's also whether there's a downward trend.
That's true, but there was no downward trend. This is 55 minutes of her in the low range. And I have to say that the chart really makes a very clean showing. It's a graph, and you can see how long she is in a hypotensive state. It is a long period. Dr. Bloom never explains how that was, it was reasonable for her to keep her in a hypotensive state and hope that there be some auto-regulation. I agree that at 12:25, when she returned to that same hypotensive state. She didn't wait 50 minutes before she rendered a vasopressor. She did it promptly. And Dr. Bloom never explained why it was necessary to do it promptly there, but it was not necessary. And it was okay to leave my client in a hypotensive state for 50 minutes. And that is the issue here. I'd ask the court to revert. Thank you.
Thank
Your
you
Honors,
very
may I just
much.
correct one issue on the record? It's only a page
No,
6.
you don't have any rebuttal time, so thank you both.
Thank you.
Okay, before Medina, the next case is Medina Diaz versus 540 West. I am going to take a 2-minute break. I need to stand up because my back is killing me. Okay, my apologies, but could not avoid it. Next case on the calendar is Medina Diaz versus 540 West. So let me hear from Appellant Saul.
Yes, good afternoon, Your Honors. May it please the court, my name is Bradford Sessa for the law office of Tremello and Fishman for the appellant. And we're here today because we believe the lower court made a mistake in granting the city summary judgment. The record shows that there are photographs at 165, 166, and 167 where the plaintiff had identified the area of her accident. And it essentially is, if you look at the photos, the sidewalk there in front of Soleil is 3 flags wide. And she picked the flag closest to the curb. And why that's important is because it's our position that broken cement area was actually an abandoned tree well from the city, and I'll get to that in a little second. But the plaintiff went on to identify that especially in 165 and 167, that the concrete looks exactly the way it did at the time of her accident. So we disagree that the court somehow accepted the position that the plaintiff fell, what I'll say is closer to the store, let's say approximately.
But you agree there's no tree there. There's no tree well. And it's a cement, which is part of the sidewalk.
It's abandoned, but then let me get to part 2 of my argument then. In terms of to the tree well, because these two issues are the outstanding discovery is sort of intertwined and therefore caused the city's motion to be premature. If you go to page 806 of the record, there's a permit there, and the permit is for the block of Soleil for planting and excavating trees in Manhattan. Now, I'm not saying that it definitely happened, there, but I'm entitled to the discovery. And the fact that the city could produce an affidavit from a record searcher at the Parks Department saying they checked 2 years back, going back to April of 2014, is belied by some of the records that somehow probably were mistakenly put in the city's disclosure to us. But the fact remains, we have this permit.
Counsel, This is
Yes,
Judge
ma'am.
Appellate. There's no tree well there.
I'm saying that I'm saying that we didn't get a chance to explore in discovery. We have this permit.
If she fell, on the day she fell, there was no tree well. She said there were no trees and no tree well. So
Right,
what
but
is there to explore? If there's no tree and no tree well, that means you're responsible for the sidewalk.
Not if, no, that's not true. 7210 carves out if the city caused or created the defect. My position is that the city caused and created the defect by the way it took care of this tree well and left it in abandoned fashion. Now we're not totally done with discovery, so I can't. I'm grasping here because you seem to be asking for more than I can produce, but that's because the lower court.
I'm asking for something. You haven't produced
the lower
anything that says your view is that there was a tree well, that you tripped on a tree well. There's no tree well. We looked at
Your Honor, it's our position. It's an abandoned tree well. We didn't get the discovery. They failed to produce a Parks witness deposition witness, and that would invariably lead to additional Parks paperwork. In the depositions that did go, they blocked the questions, and then when one got through, well, the witness is like, "Oh, I'm sorry, I can't talk about Parks. I can't interpret Parks records." So.
But Counselor, my understanding was that you conceded that you were given voluminous documents that, concerning the from the Parks Department. There was also an affidavit from someone from the Department of Parks. But more importantly, there's absolutely no indication on the photos or by your client that there was a tree well.
Well, here's the point. If you look, okay, so you can see where, if you look at 166, you can see in front of Soleil that, or to the side of it, there's a bus shelter. Then there's a pole with a bus sign on it. And then to the foreground in 166, number 1, there's the area of defect. And you can see that again in 167. You go to 1251, and you look at the picture, you see in front of Soleil, consistent with especially 167, I guess is the best comparison, the bus shelter. Moving left, you see the pole. It goes up in between the L and the E and the Soleil along the building line at the back of the van. And then you see the tree next to it. And right next to that pole is the same abandoned area in the sidewalk that I claim is a abandoned tree well pursuant to the permitting that was shown in 806. And all I'm saying is, I can't give you more than this because the city blocked me from getting the discovery that would give me a chance to prove it. And the judge in the lower court blocked me as well by granting the motion. So all I'm saying is that perhaps the city will win at the end of the day. But you know what? It was premature to grant them summary judgment without giving me the additional Parks discovery, especially when I have this.
Yeah, we got it. Thank you.
Thank you.
Let me hear from the city.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Friedman, and I am appearing for third-party defendant respondent, City of New York. Your Honor, the court correctly granted the city's motion for summary judgment, dismissing the third-party action as against the city.
Can you address Soleil's argument that they are being given an impossible burden of showing that was in fact a tree well when the employee that you produced was unwilling to give them the information necessary?
Your Honor, the city did the Department of Transportation records and Department of Parks records. There were no records that were revealed in any of the relative to this particular location. 540 West 145th Street, the sole property. The records came out negative. The Parks Department did the searches. 2 Parks Department employees actually gave affidavits saying that there were no records. The Department of Transportation did turn up a number of records, but none of the records, the sidewalk, for the sidewalk search, none of the records, none of the permits referenced this particular location. I'd also like to say that there is no evidence as to a tree or a tree well at the location. In fact, the plaintiff testified, if I could just mention what the plaintiff testified, she did not see any trees. She noticed no trees or construction near where she fell, and she didn't see anyone removing trees prior to the incident. She also testified
and also, her testimony was that she was actually walking closer to the store,
That's absolutely
to the
correct.
building, and so even if there was a tree well, that would have been closer to the curb, I would think, which is not where, because I don't think you'd have a tree well directly in front of a building. I mean, next to a building, right? So
Yes.
she said she's walking closer to the store, Soleil, than she is to the curb. Is that correct?
That is correct. She testified that the defect was not near a curb, but was on a sidewalk, and that in fact, she fell closer to the building than to the street. She actually absolutely testified to that. In terms of the pictures, the photographs that were the appellant references in the record, the page at A167 is Exhibit C. The arrow, the plaintiff testified that she did not place that arrow there. That's at page 1A, 148, and 149, her testimony. She indicated that that was the general area of where she fell. And again, Exhibit E at page A165, that was the general area of where she fell. She did testify that she tripped and fell closer to the Soule property. And in fact, there is a picture in a photograph in the record at page 166, Exhibit A, which has an arrow that points to a defect closer to the Soule property. So in fact, she also testified she didn't know who put those arrows there. So her testimony was unequivocal. She fell closer to the building. There's certainly no evidence of any tree or tree well. The other map images that are in the record, one was taken in October 2017, over a year after the accident. Even if a tree was planted after the accident a year later, the city cannot be liable for an accident that occurred a year before, even assuming there was testimony that she fell in that particular place. And then the other map images in the record, they are at pages 1252 and A1252 and A1253. They don't show any tree in that area. One was taken about a month after the accident, and the other over 3 years before the accident. They show no tree well. There's no evidence here that the city caused or created the accident or that any tree well was involved. The permit that the appellant mentions, those permits absolutely do not mention this particular property. They are very specific. One permit was for removal of trees in the sidewalk median between 140th Street and 141st Street, far from where the plaintiff allegedly fell.
Thank you, Ms. Friedman.
Thank you, Your Honor.
Thank you.
Counsel,
you get a minute in rebuttal?
Thank you. Yes, please. I think the fact that the counsel chose to argue that the location of the accident is unequivocal is belied by the record. Page 80 to 81, she identified closer to the street. Page 146 to 148, conferring with photograph at 167, she testified as to the general area. Yes, I don't mean to impose that she did the arrows. When she talked about those flags, she talked about the concrete being there. The arrows are just there emblematic to show which flag we're talking about. Now, this case was never about an active tree well. It's about the city abandoning a tree well. The permit on 806 speaks to that. The block, her block in West 145th, planting and excavating trees in Manhattan. So all I'm saying is there's enough here that I should have been given the opportunity to explore further before I got shut down. That's my biggest point here. As far as the tree well, the tree being in there, I don't know, 15, 18 months after the fact, all I'm saying is that spot in the sidewalk that she fell closer to the curb is an abandoned tree well. And to corroborate that is how things line up. The bus shelter, the pole, the tree in the spot in the area of the sidewalk means it was I get to explore whether it was a former tree well they abandoned, and in city-like fashion, it just took forever with politics to get it refilled. So all I'm saying is I should be given a chance to continue discovery, and then we can revisit everything at a later date.
Thank you so much, Counsel.
Thank you.
Thank you all. Thank you, Ms. Friedman.
Thank you.
2023 Westchester versus Ben Avenue. And I keep hearing feedback. If everybody please mute yourselves until you're ready to argue.
Good afternoon. May it please the court, Victor Metch for the appellant. I haven't argued an appeal in such a long time because of the pandemic. I feel like a very young attorney starting over. So forgive me if I feel a little nervous and anxious. So I'm joking, but I appreciate the fact that the court has this technology to keep the balls rolling.
Thank you, Mr. Mesh.
May I suggest that you all turn to the schematic survey on page 42 of the record so we can all visualize what we're talking about here. What we're talking about is the courtyard that is outlined in red on that document. And the deeds in 1947 and 1968 acknowledged an already existing easement over the courtyard.
Mr. Mesh, that was my question initially, because I know that the record at 206 talks about a 1928 was a 1928 declaration, which talks about an easement for a sewer. When did that easement turn into an ingress or egress easement for us to be discussing now? Like, when did that happen?
Well, there is only one easement chain of record, you're correct, and that's what started in 1928 as a sewer easement at a time at which there was the common owner. There's no question, the stranger to the deed doctrine does not apply to the 1928 easement. Our expert traced that easement through the chains of title of both property, and there is only one chain of title. It is correct that the 1947 and 1968 deeds now refer to that as a existing easement in use. However, there is nothing in the record one way or the other except for the fact that that is the declared state of facts to describe how that original easement somehow morphed into an easement for ingress and egress to the neighboring property.
So how would a sewer, I still don't understand, how would a sewer easement morph into an easement for ingress and egress? How is that possible?
Well, by use over time, because that property is still separated. It is an empty courtyard, and it appears, I can only surmise, because this all took place probably in the 1930s, that people continued to use that courtyard for ingress and egress. And when it came time for transactions in 1947 and 1968, a title company or somebody actually went to the site and saw that people were using it for ingress and egress. It got there for some specific reason.
Let me just ask you, you're not claiming an easement by use. You're claiming an express easement, correct?
No. We have another claim for an easement by, in fact, adverse possession, but that was not the subject of this motion.
Yeah. Right. But that was on this motion, you're only claiming an express easement.
Correct.
Right. And an express easement would require express language or specific language as to ingress and egress.
Okay. Well, I'm going to throw away my prepared remarks because here we are. Very quickly, thank you. Is that an easement can be expressed in various ways, but what we're talking about here, we never asserted that the easement was created in 47 or 68. We confirmed you can also have an acknowledgement of an existing easement. What we're claiming with this motion.
But Mr. Mensch, your ninth affirmative defense is that you have an easement of record.
Correct.
And yes. The only easement of record is for sewer, right? And then your 10th affirmative defense is that you have an easement, or you have an easement by necessity or otherwise. So we're trying to figure out, it's like, what is the nature of your claim And what is the basis for that claim?
Okay. The only claim we asserted on the motion was that the 47 and 68 deeds didn't create an easement. They acknowledged the existence of an existing easement. That was the only issue before the court. The other side created a diversion by making the argument that it was created in 47 and 68. We never claimed that. We only claimed it was acknowledgement, and there is case law, and it's cited in our brief. And if, in fact, there is a decision in that Judge Acosta was involved in last year, Your Honor, Acosta Holdings 177 Aptiv 3rd 103, which dealt with exactly this type of situation, almost our state of facts. Something happened between 1928 and 1947. We don't know what that is, but we do know that some real estate professionals, either a title company or a lawyer, or somebody who went to the scene and observed the facts, observed what was happening in that courtyard in 1947 and 1968, at which time it was being used, is used as an entrance to the building on Benedict Avenue.
Yeah, that's interesting because that's the language when in November 6th of 1947, when Lewine sold Lot 26 to Puxley Corporation, and that was the subject to language, right? Subject to the courtyard between building on said property and the building on the premises adjoining on the west, etc., is used as an entrance.
Is used, correct.
Yeah,
So,
okay.
Unfortunately, I was born a few years after that. No, actually, I was born 2 years before that. I'm sorry. I was born in 1945. I apologize. I'm not quite as inexperienced as I was trying to say.
Yeah, not 1928. Let's be clear. It wasn't the 1928 easement, please.
Okay, I was not there in 1928.
Thank you very much.
Although,
Thank you, Mr.
although my parents were brought up in the Bronx, they were probably there. But the real question is, what is the significance of the words "is used"? Those aren't words of grant. Those are words of acknowledgement, and that's our argument.
Yeah, thank you, Mr. Mensch. Let me hear from the respondents in this case.
Yes, Your Honors, my name is Stuart Cyrus from Solomon and Cyrus, and I'm the attorney for the plaintiff respondent 2023 Westchester Associates LLC. I believe that Your Honors really hit the main deficiencies of the claims and defenses and the motion of the defendant, and as this was decided by Justice Tewitt in the motion court. Respectfully, the appellant in its papers clearly moved on the basis that there was a record easement, an express easement. They've conceded that this is not an issue with respect to an easement of necessity or prescriptive easement by adverse possession or anything like that.
Well, but they did do that, right? The 10th affirmative defense is, quote, that he has an easement by necessity or otherwise.
Right, but that's not the subject of this motion. And in any event, the documents show that they front Benedict Avenue, so they clearly have access. They're not landlocked. They don't need Westchester Avenue to access the property. But the point is that they specifically, in their papers, referred to, they moved on the basis of the 1947 and 1968 deed that does referred to the easement, and their claim was that this created the easement. This is the record easement in response to our discovery demands, and this is all in the brief and the record. The only documents that they produced as proof of this recorded easement were the 1947 and 1968 deeds. They didn't even provide the sewer easement. When I opposed on the grounds that these purported easements were completely void as a result of the stranger to the deed rule, which the appellant does not dispute, and the stranger to the deed rule is that the grantees on those two deeds did not own the appellant's property at that time, and you can't.
So that's your argument. Your argument was that.
No, well, that argument has been conceded. So in reply, they produced this sewer easement, which was created when the properties were commonly owned. We don't dispute that sewer easement is there. That's not the issue. And as Your Honor's asked, how did this morph into an express easement for ingress and egress, which is a very serious claim against someone's property that must be taken seriously? It has to be in writing, and the sewer easement is what it is. Mr. Mitch has completely, through surmise and supposition, states that it acknowledges an easement, but what easement is it acknowledging? If he's conflating,
you don't dispute that the language contained in 47 when Lewine sold the lot to Porsley, and then when Porsley in 68 sold it to Pelham Realty, and basically saying subject to the easement, namely the courtyard between the building on the premises, etc. What you're saying is that neither Lewine nor Porsley could create an easement benefiting a land that they don't own. That's
exactly, and the law is absolutely clear. The appellant does not dispute that, so they pivoted and now brought in this sewer easement, which is not subject to the stranger to the deed rule, but it's a sewer easement. We don't dispute that. And this Pager case is actually on point, but in reverse. That case, as I'm sure Your Honor knows, provided that there was in fact an easement of record when the parties were when the properties were jointly owned. It was created, and then the properties were split. That applies to the sewer easement, but it doesn't apply to the 1947 and 1968 deeds, because
that's how you defeat the ninth affirmative defense. You said really that there was no easement of record. The only easement
was none, exactly, and there was nothing for us to find. It's been admitted that there's nothing of record. Now, the fact that he may have other claims, those are not subject. They are not the subject of the summary judgment.
There's no adverse possession claim in this record.
Yeah, I mean that's a counterclaim, and respectfully, Your Honor, I think that it's clear from the record, and I've asked that the court search the record and grant summary judgment to the effect that there is not an express written easement of record granting ingress and egress. My client, this started, because those documents are of record, but they're void, and it's upset our ability to get a building permit. Now, we still will have to deal with the appellant's claim of a prescriptive easement. I think the necessity can go out the window just based on.
We got you. Thank you, Mr. Series.
If I may, just very quick.
Hold on, Mr. Mitch. I gotta run this clock too. I know you can't see it, but I got a clock to run. Okay, you got a few minutes in rebuttal.
Just a couple of things. Mr. Cyrus didn't cite, in his brief, didn't cite anything in the record where we claimed that the easement was granted in 47 and 68. We never claimed that. Second is that it was of significance enough that the Department of Buildings found that it was worthy of inquiry. And third is that there is no action pending if, in fact, they want to argue that these documents have no value, then they're the plaintiff. They have the burden of proof. And in this case, that burden of proof would be clear and convincing evidence. They did not cross-move for summary judgment here. They've raised that for the first time in appeal. But I submit that they certainly haven't met their burden of clear and convincing evidence. I feel like I should maybe sing Strangers in the Night and sign off, but I will just thank you for your attention. And we look forward to the day when we can all reconvene in person. Everybody stay safe.
That is indeed my prayer. Thank you, Mr. Mesh. Thank you, Mr. Series. Good argument.
Thank you, Your Honors, and Happy New Year.
Volpe versus Cohen.
Good afternoon, Your Honors. May it please the court, my name is Rachel Morgenstern and I represent the appellant in this matter. This court should reverse the lower court's decision granting respondent pre-answer dismissal for the following reasons. First, the attorney-client relationship between respondent and appellant was ongoing, and even if it weren't, there was nonetheless a glaring conflict of interest giving rise to our legal malpractice claim. Second, because of that malpractice.
Was there an attorney-client relationship
Yes,
between the attorney and plaintiff?
Yes, Your Honor. There was an attorney-client relationship between Mr. Munoz and his law firm and both RJ LLC and one of its co-managing members, Plaintiff Ray Volpe. This is established.
But there's no retainer agreement, right?
No, Your Honor. There is no retainer agreement in this instance.
And who are the services being performed for?
Initially, Your Honor, the services were performed for RJ LLC, and those services were the drafting of corporate filings and a consulting and operating agreement. Subsequent to that drafting, there were additional services provided in the form of legal advice on legal issues such as trademark and copyright to both Ray individually and Joe Cohen. That was beginning in August of 2017, but it continued through May of 2018, I believe, Your Honor. And that's in the record on pages 71. You'll find an email dated in August.
I have a question. Your argument about a continued representation by defendant law firm with respect to the LLC and to the individual plaintiff, that I think is premised on the fact that you have an existing LLC, correct?
Yes, Your Honor.
Without an existing LLC, there's no one to represent, right?
Correct, Your Honor.
And isn't that what Supreme Court found, that the LLC ceased to exist because the contract or the deal with the company Brio had ended and it was not renewed? The consulting.
No, Your Honor. I don't believe that. Forgive me. I don't believe that Justice Sherwood spoke directly on whether the LLC ceased to exist. He did state in his.
I don't know if he said it. He was pretty clear. He kept saying Sherwood says this, Sherwood says that, Sherwood says this. Yeah. I read that transcript, and he was pummeling the attorney.
In fact, the LLC was dissolved as of April 30th of 2018, right?
No, Your Honor.
And he also pointed out that the counsel before him on the motion was trying to leave out certain parts of the agreement. He says, read exactly what it says. You've got 90 days to negotiate before the termination of the Brio consultant agreement, and that didn't go anywhere. And because that didn't go anywhere and there was no extension, the LLC itself, by its own very terms, expired because it was based, that LLC's existence was based entirely on the Brio consultant agreement. So that was all gone.
Your Honor, I'm glad you brought this point up initially. The,
Well, it's good
the
that, I
consulting-
know, brought it up. See if you could get around that.
Yes, Your Honor. The consulting agreement to which Judge Sherwood referred during oral argument has a long run-on sentence, which he described as having poor grammar usage.
No.
It has a fixed term, right?
First of all, the operating agreement was never in the record, so we don't know what's going on. We only can take at face value what everyone's telling us of. But the consulting, hold on a second. That's not the consulting agreement. They were pointing to the duration under the operating agreement at 2.4, which we don't have the operating agreement, so we can only take it what they're saying. So this is the LLC's duration, not the consulting agreement. And the LLC's thing is, you may have a run-on sentence, and you probably get Sister Mary to smack you on the knuckles for doing a run-on sentence. But it's very clear that just by looking at that context, this LLC survives only if Briel is in the mix. Period.
Honor.
Does
Forgive
that,
me, when I said it was,
doesn't 2.4 say that, or it doesn't say that?
no, Your Honor, it has a run-on sentence that is at most ambiguous as to when this LLC would cease to exist. And that was
Okay.
drafted by respondent.
So let me ask you something then. It's an ambiguous that how long this LLC exists, but are you going to deny that the LLC's existence is based on the relationship with Briel?
No,
That's
Your
why
Honor,
it was
I
formed.
would not deny that it's based on that relationship, but I would deny that it terminated and the opportunity to continue that relationship terminated with the consulting agreement. Section
Okay,
7.1.
And when did the consulting agreement terminate?
The consulting agreement expired on April 30th, 2018.
Okay, so by that argument then necessarily any representation that the law firm may have had with respect to the plaintiff LLC and the plaintiff individual terminates on that date, correct?
No, Your Honor.
No?
The operating agreement does not provide that the LLC terminates upon the end of the consulting agreement. Section 7.1 specifically clarifies any ambiguity in sections. I'm sorry, Your Honor. I don't mean to speak over.
You just said that the consulting agreement terminates in April of 2018, right?
Yes,
so
Your Honor.
If the consulting agreement terminates on 2018, you're saying that LLC still survives and continues to go further.
Yes, Your Honor.
But for what purpose? Because we know on the LLC, you have to have a purpose. So without that purpose, what's the existence then?
The purpose is to continue a broader relationship with Brielle.
Well, that the problem with that is you don't have that. You're saying that, but I don't have the operating agreement that tells me that that's the purpose. Because all you guys have is the little snippets here and there. Somebody had to give me the operating agreement, and that's what Justice Sherwood was getting on the counsel about. Where's the operating agreement? So you're telling me something, but there's nothing to back that up with what you're saying.
Your Honor, the operating agreement, though not attached either to the moving papers or to our opposition, is quoted in the complaint. And
it's quoted, but what you're saying is that the purpose is, because my position is once you lose your purpose, the LLC doesn't cease to exist. And you're saying, no, the purpose is to continue to try to have a relationship with Brielle. That's what you're saying, right? Where is it in the complaint that you say that?
Your Honor, in the complaint, it is stated, as it is in the consulting agreement, that
you're mixing the two things up. I don't care about the consulting. I'm looking at the LLC now, the operating agreement, because the operating agreement is what really drives this case. Because that's the engine that drives this case.
On page 63 of the record, Your Honor, there is, forgive me, I don't remember if it is the consulting agreement or operating agreement, a statement by the parties that this relationship with Brielle was to be, this is expressly stated, a long-term, multifaceted relationship, not limited to the specific consulting agreement. This is supposed to be a broader relationship that continues beyond the consulting agreement. And the LLC did not cease to exist. Section 7.1 of the operating agreement, to which Your Honor refers, specifies that the LLC would only be dissolved upon unanimous consent or formal declaration of judicial dissolution. So to the extent the section you referred to previously, section 2.4, the run-on sentence, has any ambiguity, section 7.1 should clarify that ambiguity and indicate that the LLC did not cease to exist. There was no formal declaration.
All right, let me hear from the other side. We spent 8 minutes so far, so way over. So
Thank you, Your Honor. This is Anthony Green of Wingate Spetafor and Schwartzberg on behalf of the respondents, and I think we've very well spoken to the central issue here, which is that the LLC did not continue to exist. It did depend on the existence of a consulting agreement with Brielle. And if you look at 1.4, yes, maybe it is a run-on sentence, but it does, the first precedent is that it will continue in existence for so long as the agreement with Brielle Ventures, Inc. and any extension thereof remains in effect until it is dissolved otherwise. So yes,
was the operating agreement ever renewed prior to April 30th of 18?
I'm sorry, the consulting agreement, do you mean?
Yeah.
Or, yes, yeah. No, it was not. It was not. It terminated on April 30th, 2018, and if they were to extend it, they were supposed to do that 90 days in advance.
Right. Prior to April, 90 days prior to April 30th.
Yes, Your Honor. And instead,
so what is the practical implication of that? And that the defendant is free to represent what is it, Woodbridge Brielle, or was basically able to do anything he wanted or represent anyone he wanted, subject to ethical rules.
Right. And there's no private right of action on with respect to ethical rules. Just as an aside, but the consulting agreement had ended, and then there's this basic causation problem, is that it was never there was never any, it was unfruitful, any discussions with Brielle that happened after the consulting agreement expired, so it was never revived.
But that's only with respect to the allegation that they lost corporate opportunities, right?
Correct. But that's the damages that they claim, and that there's no causation there because the relationship had already ceased to exist.
Okay. All right. Thank you so much.
All right. Thank you, Your Honor.
You get 1 minute, Ms. Morgenstern. I mean, I shortened the time on opposition.
Thank you, Your Honor. With respect to the timing of these events, I would just like to note that in June 2018, long after the expiration of the consulting agreement, the parties relevant here met at Joe Cohen's offices. That means Joe, Ray, and respondent, together with the Boudet brothers, Brielle's members. And they were meeting to discuss potential investment information sessions, future business. At no time was it stated that RJ LLC ceased to exist. At no time was appellant under the impression that that had happened. No parties acted as if that was the case. It wasn't the case. RJ LLC had continued to exist, and they were on the verge of continuing negotiations and on the verge of moving forward with that. Had respondents not supplanted that opportunity would have and should have belonged rightfully to RJ LLC. Thank you.
Okay. Thank you. Thank you both.
Thank you, Your Honor.
Okay, Morales.
Good afternoon. May it please the court. I'm Alan Zachary from Williams, Schweitzer and Associates, representing the plaintiff appellant, Jose Morales. It's plaintiff's position that he was entitled to summary judgment under Labor Law 240, subsection 1, because when he fell off when a closed A-frame ladder that he was using leaned up against the wall, slid out from underneath him unexpectedly. That testimony is undisputed. It's shown in a video, and that establishes the prima facie case. But also,
was the plaintiff ever asked to use a different ladder?
Plaintiff was not asked to use another ladder. He testified that he asked his supervisor to use a different device, but granted, his supervisor did not recall being asked that and disputed that, but that doesn't.
Hey, counsel, I got a question. This is Judge Owing. I got a question. You know, there's an 8-foot ladder and a 12-foot ladder. Wasn't the video showing that the supervisor was actually carrying the 12-foot ladder while the plaintiff was using the 8-foot ladder? I mean,
correct. I mean,
right?
the video shows that that at the time that plaintiff was directed to do his work,
Right.
his supervisor was using the other ladder.
Exactly. So that's what I'm saying,
So
because
it
there's an
wasn't an
argument here
available
that
device.
right. There's an argument here that your client, you're the plaintiff, correct?
Correct.
Your client should have gotten the 12-foot ladder. Well, that's kind of hard if someone else is using it.
Correct. Not only did it wasn't in use. Once the video shows that once the supervisor finished using it, he walks by the plaintiff. He testified that he saw plaintiff using the shorter one in the closed position. He did nothing. He didn't say, here's the taller ladder that you should be using. He didn't tell him not to stand on the closed ladder. And the supervisor also testified that he didn't necessarily think that it was a bad idea or against safety protocols to use the ladder in the closed position. So plaintiff can't be the sole proximate cause of his injuries when he was doing it with the tacit permission at minimum, with tacit permission.
It's not like, the questions that I asked you before were with respect to a recalcitrant worker. It's not that the supervisor offered him the ladder once he finished using it, and your client refused to use it for no good reason.
Correct. And there's no instruction that he was.
Okay. Thank you, Mr. Zachary.
Okay.
From respondent.
Thomas Cooper on behalf of the respondent. Respectfully, I would suggest that the issue is not whether the plaintiff was recalcitrant, but as per the Cahill case, whether his conduct can be deemed the sole proximate cause of the accident. And in that regard, there's no dispute that a 12-foot ladder was available to him. And Funes testified that the plaintiff actually used the 12-foot ladder later that day.
He used what was available to him because the supervisor was using the other ladder, right?
Yeah, but as per the case law, Your Honor, there is prior precedent which states that does not require the supervisor to make a direct command that he use a particular ladder.
No, but according to that same,
he never asked Funes to employ the 12-foot.
Mr. Cooper, the 12-foot ladder has to be available, right? That's what our own precedent says. It has to be available. It was not available because it was being used by the supervisor, right?
He could, if it was inappropriate, it was still the worker's burden to ask for it, Your Honor.
No, not if there isn't available. If I know that there are only two ladders and I see my supervisor using the other ladder, I use what's available. And the supervisor himself said that he was using the smaller ladder and it really didn't matter. It was quite appropriate for him to do so. That's what the whole nature of 240 in all of the cases, including Blake, is a case that I think is on point here. In a lot of the other First Department cases.
Yeah, counsel, this is Judge Jong, and I don't think the supervisor testified that he told the plaintiff, hold on a second, I'm using the 12-foot ladder. Give me a minute, let me finish what I'm doing, and I'll come over and help you with the 12-foot ladder. Did he say something? Did he testify to that extent? No, I don't think so, unless I read the wrong record.
No.
I don't think he testified to that, right? Say to the plaintiff saying, oh, wait a second, I'm using the 12-foot ladder. Give me a second. Don't use that 8-foot ladder. I'll be right over there.
But your honors, I would like to direct your attention to pages 213 and 214 of the record and 219 and 220 of the record, where the plaintiff testified that there was enough room for him to open the ladder that he was using and use it safely. He contradicted, there is an internal contradiction in the plaintiff's own testimony, which should be resolved by the trier of fact and not summarily.
So at the very least, that may be comparative negligence, but this is a 240 claim, right? This is a statutory claim.
And this is Judge Scarpullo. The burden is not on him, it's on the employer. That's the whole purpose of the statute. It's not for him to beg for the right equipment. The burden is on the employer to make sure that he's using the right equipment. That has been clear for 35 years.
And not only 35 years, but also recently in in Valdez versus the City of New York, where Justice Owing and myself sat on that panel. For a recalcitrant employee, you still need to show that he was given specific instructions which he refused to follow. And that is not present in this case.
Well, that's not what Cahill says.
Cahill talks about sole proximate cause and the recalcitrant employee. That's what Cahill talks about.
No,
again,
Cahill, and in Cahill, they say even when a worker is not recalcitrant, there can be no liability because when the worker's actions are the sole proximate cause of the accident. I think the focus on recalcitrance really distorts the inquiry.
Well, that may be your opinion, but that's not what the case law states.
Yeah, remember that what I told you before, that in fact, the language that I read to you before is from Bianca Nieto, which is a Court of Appeals case quoting Cahill. So the fact is that it is the defendant that has to establish that, among other things, plaintiff knew that the taller ladder was available for his use and that he was expected to use the taller ladder for his work, and the recalcitrant piece is just simply with respect to whether he chose to use the shorter ladder for no good reason. But the reality is the taller ladder was never available to him.
On page 537 to 539, Funes testified that the plaintiff knew of the existence of the 12-foot ladder and that he had to get it.
We're talking about the availability. We're talking about the availability, not the existence.
Understood.
Availability, because the supervisor was the one who was using that ladder, so it was unavailable.
Thank you, Mr. Cooper. Thank you, Mr. Sacre.
Thank you, Your Honor.
Hearing the arguments, you want your minute rebuttal, or you good?
The only thing I'd like to point out is that, Your Honor, is that plaintiff did say that he tried to opened up the ladder in the area, but when he opened it up, he couldn't reach the area he needed to work. So the extent that they're saying that I think the court clearly has a grasp of all the issues.
Thank you. Thank you so much. Thank you both.
Thank you.
Okay, Engelman versus Rolfe. Ruffy? Rolfe, okay. Sorry.
My understanding is Rolfe. Good afternoon again, Your Honors. Annette Hasapidas appearing for the plaintiffs.
Yeah, doing double duty.
Well, you're looking even better the second time around.
I think it's Judge Weber. The last time I had two cases before the panel, Judge Weber was on the panel as well. So you're my good luck charm. Thank you for that. Respectfully, the lower court erred in dismissing the complaint in this action. First, the court held that plaintiff's claims of negligence against defendants, against PDR Voice, were intentional torts in disguise. The plaintiff's complaints allegations pleaded a breach of a duty of care to PDR Voice's students. I'd refer the court to Green versus Emmanuel Church, cited at page 11 of the brief, where simply because an agent of a corporation commits an intentional tort does not mean that the corporation cannot be cast in damages for negligence. Frankly, this is akin to, a bar owner being responsible if a bartender assaults a patron. The bar owner is responsible for the intentional torts of its employee. And I'd submit to you that the court erred in rejecting all of the negligence claims as untimely intentional tort claims that were mispleaded.
What about the VGM claim, Ms. Hasapidas?
Yes, Your Honor. The court also, again, with all due respect, incorrectly dismissed the GMVA claim as preempted. I'd like to take a quick look at the analysis that the court engaged in. The court looked at section 215 of the CPLR at the defendant's behest and said, well, the allegations of misconduct committed by Mr. Rolfe fit within section 215 of the CPLR 215 has a 1-year statute of limitations. Therefore, the GMVA has a 1-year statute of limitations. And then, and at page 23 of the court's decision, the court says, obviously, there are other statutes of limitations for other crimes, and they're different, but they don't apply here. So the court's analysis.
The argument is, I mean, the city council is not prevented as a municipality from creating a private right of action to benefit victims of gender-motivated violence, right?
That's correct. But the court's analysis here essentially said that whether or not a GMVA claim has a 1-year statute of limitations or a 20-year statute of limitations, which would be for a rape victim, turns on, Article 2. And that's never the way we've ever construed statutes of limitations, right?
Right.
You have to understand.
It's not how we construe other private right of actions that have been created pursuant to the city human rights law, to the state human rights law, and other private right of actions to protect victims of discrimination, including gender motivated violence.
Correct. And so stepping back, the court attempted to engage in a preemption analysis, but that analysis had to start with the content of the statute and the legislative history, and that is clearly a civil rights legislative history. It was intended.
Yeah, no, you don't need to argue that one. The fact is that the state has not preempted the field, nor has the federal. I mean, on anti-discrimination statute, Title VII never prevented the state human rights law from being created or the city human rights law. Municipalities have a right to protect victims of discrimination more than state and federal level. Williams says that, right? It's a ceiling, not a floor.
Correct. There is no conflict. There is no intention by the legislature to provide statutes of limitation in all areas of law. Your Honor, it seems that you don't have questions on the GMVA.
Well, no, VGM, no, I don't. Can you address the hiring and supervision claim?
Yes, thank you, Your Honor. That's what I would like to pivot to. It was error for the court to conclude that because Mr. Roffe is the sole owner and shareholder of PDR Voice, that PDR Voice could not be cast in damages for negligent hiring and training. When Mr. Roffe chose to create a corporation in order to conduct business, he chose to create a separate legal entity in order to insulate himself, among other reasons, from certain liabilities, right? It creates a buffer. However, the law does not view the corporation and the agent, even if it is the sole owner, as as one and the same. That would be a partnership.
Counselor, how do you negligent hire or negligent supervise yourself?
Your Honor, this is a pre-answer motion to dismiss. Discovery may show that there was a policy in place by this corporation created by Mr. Roffe and or with respect to whether to meet students privately.
But let's talk about first, how do you negligently hire yourself? How does one do that? Because this is not, I mean, we're talking about this specific claim and your attempt to shoehorn into it.
Yes.
So I want to know how you think anyone can negligently hire themselves, right? Because the negligent hiring claim is I hire someone else negligently. How is it that you could do that to yourself?
If he had a history of molesting women prior to creating PDR Voice in situations where he was alone with women, he could have made a decision early on, you know what, maybe I should make sure that I am not alone with these women, so I do not have this compulsion, as I'm speaking hypothetically.
So you're saying he has an obligation?
Yes, I should hire other voice coaches to engage in this business and not myself, because I know that I am not going to be able to control myself. As the officer of the company, he made a decision that he should be the only voice coach. There are other employees, as he testified in a related action. He never chose to hire a voice coach. He never chose to hire an assistant to be in the room with him. He chose to hire himself on behalf of the corporation to meet with these women privately and engage in sexual misconduct. And that
was a fortiori, anyone who was sued would automatically also be subject to this claim. And in this case, that would also mean someone who was a subchapter X S corporation in every other context, not just this case, but in any negligence context. If they ran their own business, they would automatically be subject to a negligent hiring claim. That they should have known that they wouldn't see the glass on the floor or the water on the floor. They should have known that they didn't have, that they didn't have the wherewithal to do this. That's what you're saying, that we should ask our trial judges to apply.
I am saying that at the pre-answer stage, the pre-answer stage, in the absence of discovery, this is not going to be duplicative. We're deposing the same people. We're conducting discovery of PDR voice. At the pre-answer stage, it is premature to draw these conclusions. That he
only if you think there's a claim, right? Only if you think that your allegations state a claim. But if they don't state a claim under that law, then this is the right time to get rid of it.
So, counsel, this is Judge Owing. The way I look at it is that you've alleged that this corporation, you're alleging a direct claim, or you're asserting a direct claim against the corporation, correct? For negligent hiring.
Negligent hiring, negligence, and yes, and negligent.
Okay, but at bottom, it's a direct claim against the corporation for its single individual under this S corporation, S chapter corporation, correct?
Yeah.
The way I look at it, the defendants are looking or move to dismiss based on their argument of an S corporation, that you can't, how can a corporation negligently hire or supervise itself because it's only one person, correct? So that they're making that argument, I think, right? Correct?
Yeah. Yeah.
So isn't that more in terms of requiring, like you said, discovery? Because I don't know exactly what the setup of the S corporation is. I don't know what the terms are. I don't know. I mean, they're just floating it out there saying, oh, my defense is the S corporation. But in discovery, it may turn out to be a totally different situation because unless I've overlooked something in the record here, I don't believe the details of the S corporation's incorporation was put forward in this record.
That's correct, Your Honor. That's part of the point here. We're speculating. He could have, in order to be able to solicit students, and he might be a member of, the company might be a member of an organization and was required to submit documentation to establish their qualifications to provide voice coaching lessons. We don't know whether the corporation prepared that. Plus, we're prematurely disregarding the clear distinction.
Right. It can't be. It can't. The defense of the argument. Yes. So the argument that he's raising cannot be determined as a matter of law. Right. That the S corporation at this juncture, at the pre-answer stage, can't be sued directly.
Yes. And I would also point out that you can't accept their allegations. They falsely came forward in their motion to dismiss and said PDR Voice has no employees. So in opposition, we pulled Mr. Rofe's deposition testimony in his
in his deposition testimony. He said that he had at least two to three other employees, including the sound engineer and his wife, who also worked at times. But the point again, but made by Justice Owing, is that again we're talking about a pre-pleading motion, and we're talking about not knowing exactly what the specifics are as to his relationship to this corporation, if in fact it is a.
I just want to ask you one question though. If it turns out, are you arguing, if it turns out that he is just the one person, that nobody else is in the S subcorp, that he is the corporation, are you saying that you still, if that turns out to be the fact, you're saying you still have a claim for negligent hiring and negligent supervision?
I would say I still have a claim if that's the case and there's evidence that he's a member of an organization, he vouched for his qualifications and said that voiceover lessons would be given in a certain safe, secure setting so that these people can get in touch with themselves and really bring their emotion and heart to their singing.
And if you made such a showing, there would be a motion for summary judgment, and then that would be decided, and then depending upon the determination, we'd be right back here, but with a fuller record in order to actually render a determination. Is that correct?
Yes, at this point, I'd submit we're reading the tea leaves, and we could spin on this for a while, but I acknowledge my time is running.
Including trying to look at other statutes where statutory liability is created, even when there's only a sole owner. And in fact, a corporation with one employee can be exempted from punitive damages if they have systems in place to detect and address discriminatory practices. So it's not unusual for, especially when you have a corporation that's separate and apart as a corporate entity, separate from the employee and the owner.
And you also have several methods already to get to that corporation that don't involve kind of shoehorning in to a negligent supervision, right? You have vicarious liability, you have post-judgment remedies, all of that.
So the issue, counsel, the bottom line, the issue here that I see for this remaining issue is whether or not there's a direct claim, whether or not there is a possibility or at least a theory for you to assert a direct claim against the corporation. And the way that this is played out and the difficulty of all of this to answer that question is that we don't have a full enough record. We don't have enough of a record here to make that determination at this point. There's just too many moving parts.
Yeah, you don't have to answer that, Ms. Hasapides. We got 13 minutes with you already, so let me hear from the other side.
Thank you.
Good afternoon, Your Honors. May it please the court, Crystal Massarelli of counsel to the law firm of David Klausner for the respondent, defendants Rofe and PDR Voice. I will start with responding, I guess, to the negligent supervision claim. And I submit to the court that the simple notion is one cannot supervise or retain himself. This is unequivocal.
Counsel, this is Judge.
I'm sorry. Go ahead, Jeff.
Counsel, this is Judge Owing. So we all agree you can't supervise and hire yourself. Okay. My question is there right now at the pre-answer stage an ability for the plaintiffs to assert a direct claim against the corporation? And your response to it is exactly that. This is a subchapter S corporation. There's only one person involved here, and it's the individual defendant. And my response to that would be, unless I overlooked it because I got so many appeals here, is there anything in the record that tells me or at least indicates to me how this subchapter S corporation was formed and who is now currently in charge, and then what the relevant period of time, who was in charge and who were the members?
There is the affidavit that was submitted by the S Corp's accountant, which sets forth that there were no employees at the time of the alleged allegations.
What about the records in all the related actions where you've admitted that you had employees? Do we take that into account?
His deposition testimony, he specifically testified that in 2015, which is one of the relevant years, he had employees. This is before I think he moved to New Jersey, if I'm not mistaken. He said when he moved from Flatiron to New Jersey, he stated he had a sound engineer. He also stated that his wife worked as well, so that he did in fact have employees, and that he himself was an employee. This is on the Med-Mal case.
Yes, Your Honor, I hear that point, but it's still a sole owner and there's no management above him. There is no allegations in the plaintiff's complaint that anyone other than Rofe committed the acts and that there was any separate board or any other management entity which could have been in charge of supervising.
So Ms. Massarelli, as a matter of public policy, you're saying that the way to get around being charged with molesting and groping and all kinds of sexual misconduct is basically by creating a corporation and insulating yourself.
No, Your Honors, I'm not
liable if it's only you.
No, respectfully, Your Honors, I am not saying that. There was a mechanism, a timely mechanism where they could have brought this claim, but they didn't do that. And had they brought the claim within the 1 year, they could have gotten vicarious liability.
Why 1 year? So I guess we're going into the VGM claim. Why cannot the city council create a private right of action as it did with the state human rights law, as in fact this section BGN was originally to be included as part of the city human rights law, and it wasn't. But city human rights law has its own statute of limitation, other statutes that are created. So why does 215 even apply here? The question is whether the municipality has the underlying power to protect victims of sexually related misconduct more than they do, other crimes, for example.
I've recognized all of those points, and I'll address them with three counterpoints. One, the New York City and the human rights law ascribes a 3-year statute of limitations in accord with the CPLR. The CPLR is a statute of repose. It is a general law. It is one that is applied across all of the courts of this state. And if it weren't, we would have utter chaos. I could go into New York City and there'd be one statute of limitations. But if I went into Rockland County, there could be another statute of limitations.
But maybe that was the legislative policy choice that the city council made. But with respect to, you take, for example, the ability to seek judicial review of administrative orders. In some instances, you have 30 days. Some instances, you have 60 days. In some other administrative orders, you have 6 months. So, it doesn't create chaos. The question is not whether, the question is whether the city council has the power to enact it.
And they have the power to the substantive law, but they don't have a power to assign to it a statute of limitations that is not in accord with the CPLR. Just like a 1983 action can be brought in a state court, but it had to defer to the CPLR. It is the law of the state.
You don't think that there is a distinction between a general assault against a woman, and that doesn't differ from a gender-motivated violent act against a woman? I thought Brees responded to that, right?
Brees did, and under Brees said that the difference, that the animus comes from the consent, and the consent is encompassed in an assault and battery claim. So the essential elements are the same. The difference is, and what the state of New York has done, recognizing the very same thing that the GMVA sought to recognize, that there is distinctions between the type of crimes and the type of sexual violent acts that women are subjected to. And that they were very carefully took note of that when they went through not one, not two, not three, 6 different sections of the CPLR to provide and protect women who are subjected.
Well, the argument to that is the more the merrier.
I agree, but the city of New York still has to defer to the state of New York, who has the sole power and ability to set the statute.
Why?
Because it's the general law of the state.
Because I'm sorry,
that's as long as the state has not preempted the field. The anti-discrimination field has not been preempted by the state. In fact, the city is allowed to create more protective statutes that protect more than the state and the feds.
I agree with you on that point, but the issue is differentiating out the substantive versus the statute of limitations. I'm not saying the GMVA can't stand. It can, but the statute of limitations it aside cannot. And as pled in this case, let's talk about the pleadings of this case, because that's what's before this court. On the pleadings of this case, they don't meet any of the requirements to give them a longer statute of limitations.
Counselor, I'm sorry. Why is it the statute of limitations would not be able to stand the broader statute of limitations?
Because the home rule only provides for a local municipality to enact a law that does not conflict with a state constitution law or one where the state has not enacted a general law.
What's the basis for your argument? What do you base that upon?
What do I base that?
Yes.
if you look at Albany versus Area Builders Association versus the town of Gutterley, it is the primary, is one of the cases which sets forth the rule of preemption.
No, not the rule of
Right. So
what are you
it's based
saying?
on a
This is
preemption argument.
preempted. What are you saying? What's the case that says that discrimination law is preempted by the?
But you can't, I'm not saying the discrimination law is preempted. What I am saying is that
if it's not, then why can't the city put in its own statute of limitations?
Because statute of limitations are preempted. They're
All
preempted.
statutes of limitations?
They're not. I don't think that you can cite a
In
case.
civil causes of action where in fact the court, the state of New York has codified the law, and they've set forth this expansive Article 2, which sets forth all common law causes of action.
Right.
And they codified
except for the causes of actions that are created based on a different policy choice. So you're saying the city council cannot determine that because women that are subject to the kind of conduct involved in this case may take longer to come forward or are reluctant to come forward, and therefore they should get more time to bring their causes of action. You're saying that the city council cannot do that.
I'm saying
that they have to basically, whatever private action, let me finish it, that whatever private action gets created has to conform with pre-existing codified statute of limitations. That's what your argument is.
That is what my argument is, Your Honors. And I'm saying that yes. And if you look at 214 and the statute, you have 213B, you have 214G, you have 213C. The state legislature, and if you look at the intent there, they said, listen, we recognize that women who are victims of violent sexual assault need more time to come into the courts. And in fact, in 2000, the legislature amended it to some of the statutes to increase for additional times for the very purpose. And had the plaintiffs in this case alleged any of the enumerated crimes, sexual assaults that the state legislature has sought to give additional time, they would have gotten it.
I don't think that the assertion of the claim is dependent on what the state decided to do in response to Morrison. The city decided, as a matter of policy, to respond to the U.S. Supreme Court decision in Morrison by saying, no, we are going to protect women who are subjected to this kind of conduct. And the question is whether they have the power to do that. I believe that they do have the power, and you haven't cited a case for that proposition, but that's something that I'll look at.
Cordero versus Epstein is, although not appellate division and not binding on this court, but it went through the same analysis. And understand, the VAWA was to protect women who were victims of rape, violent domestic violence, and stalking. If you look at the CPLR article provisions, 214C, 213B, they carve out those very extensive additional time limitations for those women to come forth and do it. You can't say that the state legislature did not preempt this field. They carefully did it even before the GMVA did it.
Yeah, I mean, the fact is, Ms. Massarelli, that all of the entire city human rights law is a response to Reagan-era anti-plaintiff discrimination rulings. And that was the precise policy choice that was made at that time when it was enacted in September of 1991 and subsequently in 2005 and other times. But great arguments. Thank you both. I think Mrs. I gave you 13 minutes up front, so I gave you 30 seconds in rebuttal.
That's great. I appreciate that. Council has made a claim of conflict preemption. I'd refer the court to section 201 of the CPLR that says an action must be commenced within the time frame specified in this article unless a different time is prescribed by law. The legislature contemplated other statutes of limitation and did not intend to preempt the field. I would also point out that there is no civil rights statute of limitations provided for in Article 2, and therefore the GMVA statute of limitations is not preempted. I thank you, Your Honor, for giving me that added time.
Thank you. Thank you both. Great
Your Honor,
argument.
never mind. It's fine.
Rappaport. You are muted, Ms. Joseph.
I'm sorry, I'm trying to get out. Sorry.
I just unmuted. That was a very interesting argument on the statute of limitations. I'm Linda Joseph. I'm with Schroeder Joseph and Associates, and I represent the defendants appellants here. And we are appealing in particular defendant Strategic Financial Solutions LLC's counterclaims were dismissed pre-answer. And our position is that they should be permitted to go forward, certainly at this early stage of the case. And they're basically two counterclaims that have been asserted by Strategic. One is a claim based on material omission of fact, fraud in connection with the acquisition. The plaintiff here is Mr. Rappaport, who was the chief officer of Pureform, which was acquired by my client. And our position is that Mr. Rappaport knew in advance of the closing of this transaction, which included representations, and he was the one who signed the agreements and so forth on behalf of Pureform, but it contained provisions that required a representation that there were no material changes with respect to the financial documents that have been provided to us in due diligence. And in fact, he knew that the primary lender, in a sense you might call customer of this Pureform, had already decided that it was no longer going to do business with Pureform. And he knew this in advance of the closing. He was the only one who knew it. And our clients ended up paying $10 million more for the company than they otherwise would have paid.
Counselor, excuse me, in terms of your fraud counterclaim, what allegations were there that you took any steps to probe the strength and longevity of the critical customer relationship? What steps did you take? What did you do to show that you know exactly what you did in terms of the customer relationship?
The allegations in the complaint pertain to the due diligence that we had engaged in. We also had an affidavit before the court as well, and there were financial documents that were provided that were dated in July, and we included in the contract that there were no material changes to those financial documents. That was a representation that Mr. Rappaport made on behalf of Pureform. And so we were entitled to rely on that. Wait,
but counsel, this is Judge Scarpullo. You still haven't said, what did you do? What did you go to Pureform yourself? I mean, you knew this was the big deal. So what did you do for yourself? I mean, you have the opportunity to go to Pureform and ask them what's their plan, what are they going to do, what have you alleged with respect to that?
Well, we didn't make allegations with respect to that.
Right.
Exactly. That was my question. I did not see any allegations. So if there is a lack of allegations, how then do we sustain the counterclaim for fraud? Don't you need allegations?
Well, and if we look at the case law with regard to reasonable reliance in this kind of a context where we have engaged in due diligence, when we have made a request in the agreement that there have been no material changes, we're entitled to rely on those representations. We're not obligated to conduct some kind of discovery with regard to every customer of the company. This is
no, but this is the biggest company. This is the biggest client, right? The number one client, right?
That's
true. What is the representation about in the contract? Where is the representation about the continued business in your sale agreement? Where is that representation?
The contract says that there have been no material changes in the business. Now, if I am Mr. Rappaport and I know that the biggest customer has told me they're not going to continue, and they are on the list of customers. The volume in the due diligence and in the balance sheets and et cetera that were provided to us, I am entitled to rely on the fact that he represented there were no material changes.
So you're saying that it was an omission. And then my question again goes to you is, in that context, what due diligence did you do about that client?
We did not interview the client.
You didn't do anything. You didn't talk to them. You didn't ask them. And there was no specific representation. This is an omission case.
Respectfully, the case law is such that when you have that kind of contract, even though it's a commercial contract, and even though the business people are sophisticated, they are entitled, when they are provided with balance sheets during the due diligence process, and sales information, and they include in the contract.
So they should have known. They should have known, based upon this contract, they should have known that Ranger's continued existence was critical to Paraform's ability to attract new business, for example.
They were entitled to rely on the fact that they were told that that was the situation, and there were no material changes in that documentation that was provided in the due diligence.
What is the material change that you're alleging? I mean, are the numbers wrong?
The numbers.
Are the numbers wrong? That's what I'm trying to figure out. You keep saying there's a mistake or a misrepresentation in this financial document. What is it?
No, what I am saying, Your Honor, and I'm sorry if I was not clear on this, what I am saying is that Ranger came to Mr. Rappaport and told him that they were no longer going to do business, that they were planning on ending their relationship. He did not disclose that. That's a material omission.
That was an omission. So I'm saying to you, in that context, what due diligence did you do to see, to find out about the nature of that relationship? You're saying you had no obligation whatsoever to do any due diligence.
I thought, maybe I'm confused, but I thought that you are required to at least plead that you will not have protected yourselves through due diligence. That you couldn't have protected yourself through due diligence.
I think that we have pled that. We've pled that we didn't know it. He knew it. He didn't disclose it to us. What he did disclose to us were facts that showed us that there was a continuing relationship. We included in the agreement itself a provision, an express provision that said that there were no material changes with respect to the documentation that he provided to us.
And that's what I'm asking you. What what was the change in the document? And you keep saying none. It's something that's going to happen in the future. And so the documents that they gave you are correct. And he didn't tell you something that, and you're saying, but I didn't have an obligation to find that out myself.
The change is that he knew that there was a new situation that wasn't reflected in the documents and that he should have disclosed to us because he had a fiduciary duty to do that.
He's not your fiduciary. He's selling his business to you. He's the opposite of a fiduciary. There's zero fiduciary there.
He had a duty because he signed the contract. He made these representations on behalf of the company. He also acquired, he obtained a part of the acquisition was that he was going to be hired. He was going to be a manager in our company, and he was going to have a lucrative contract. And that imposed on him a duty. You're right, Your Honor. I'm not saying that he was a fiduciary, but he had an obligation, a duty as a matter of law by reason of those circumstances.
Thank you, Ms. Joseph.
Thank you.
Let me hear from respondent.
You're muted. Unmute, Counselor.
Thank you, Your Honors. I knew I would screw that up. Chris Lowe from Lipsky Lowe LLP for the respondent Rappaport here. I think the court is asking all the right questions with respect to the fraud claim. And I think the brief from my adversary somewhat mischaracterizes our position. We did advance other arguments that were put forth below that the court didn't necessarily address, but that was in no way a concession that the trial court got this issue wrong. It has been our position and continues to be our position that the fraud claim was properly dismissed because it is relating to a future action or event.
Counselor, Judge Scarpula, I want to ask you about the breach of contract claim, which is that you breached the confidentiality provision of your employment contract by disclosing certain information in a lawsuit. What's wrong with that claim? It seems like a perfectly good claim to me.
Well, I think there's a number of things wrong with it. First of all, I think what my adversaries focused on a lot in their brief is sort of characterizations of what they alleged, as opposed to what.
I mean, we don't know right now. We don't know right now. We don't know what it is, but there is an allegation that confidential information, your client clearly had it, and he put out some stuff in another complaint that could be considered that way.
Right,
so why should we dismiss that now?
But respectfully, we know exactly what it is because we have the confidentiality provision and we have the complaint. There's no allegation that needs to be discovered through discovery. There's no facts related.
Did your client not put out some financial information about the company in his complaint?
There is financial information about the.
Isn't that clearly or at least arguably confidential information under his employment agreement?
Respectfully, the provision itself talks about sales and profit figures, and those are the sort of categories that apply here. None of these are sales and profit figures.
No,
did he also discuss SFS's plans to borrow funds, which would he discussed that as well. He had that as well.
There is this paragraph about borrowings. You are correct, Your Honor. But again,
so would that not, go directly to this issue in terms of the breach of the employment agreement?
It would if the contract was broad enough to cover that, and I don't believe that it is. Alternatively,
you don't think that that's confidential information?
Not as well. Yeah, it might be confidential information in layman's terms as you and I are discussing it, but what we have to focus on is what does the contract say and what does the complaint say? And alternatively, I will submit that there can't be a breach of contract claim here that's viable and that it was properly dismissed because there's no damages asserted. And even in plaintiff's brief, they say, oh, well, we put in some what we anticipate damages might be. Well, that's not damages. That's the same speculation that was in.
You argue that they were speculative, but you yourself admit that the information is quote unquote valuable and a unique asset, right?
I'm not sure I follow your question, Your Honor.
Yeah, it doesn't matter.
Okay, and then the last thing is I wanted to address the litigation privilege, which plaintiff says that the litigation privilege doesn't apply, but in fact the complaint at issue specifically sets forth damages, monetary damages as a result of this action. It's not just documents. The initial complaint in this case had damages provision, which honestly would not be understood or explained and probably would have drawn a motion to dismiss in its own right had it not disclosed the financial information and what was at stake in terms of distributions. And the distributions themselves that were described in the complaint were limited to the individuals who were suing in the action and did not describe distributions for everyone under the contract. So in what we know with respect to the litigation.
I don't understand that argument, counsel. What is that argument? What is that? I totally don't understand what relevance that has. If you disclose confidential information, it doesn't matter whether you disclose it worldwide or to 13 people. You breached. So I'm not clear what you're saying. What is it that you're talking about?
Well, what I'm saying, Your Honor, is they only disclosed to the extent they needed to disclose to establish their claim for damages.
Well, then that might go to the issue of damages, which I think Judge Acosta correctly pointed out. You agreed in the contract that that information was valuable, and the breach would be something that you would lose value for. That's why you put that in a contract like that, is so that there isn't any ambiguity or there isn't any question that someone is going to suffer from the loss of confidential information. It's just a matter of how much, right? You don't put that, that's not superfluous language in the confidentiality agreement. It's there for a reason.
Thank you, Mr. Lowe.
Thank you, Your Honors.
I would like to just briefly respond, if I could, Your Honors.
You can. You got a minute.
Okay. On page 208 of the record, which is attached to our counterclaim, there is a provision in the agreement which I think responds to the questions you were asking earlier in terms of our reliance, and that is section 2.6 of the agreement says, absence of certain changes, except as otherwise contemplated or permitted by this agreement, since the date of the company balance sheet until the closing date, there has not been a company material adverse effect, and the company has been operated in all material respects in the ordinary course of business consistent with past practice. That is the provision that we're entitled to rely on, which I believe gives us the right to bring the fraud claim. As to the claim with respect to breach of contract, I think the court understands that and has a very firm grasp of it. I don't think that cause of action should have been dismissed. And there was no need to disclose profits or the anticipated borrowings that were planned or anything else in terms of the issue of the litigation privilege. But thank you very much, Your Honors.
Thank you, Ms. Joseph.
Your Honor,
Thank you, Mr. Lowe.
May I be heard on 2.6? As
No, Mr. Lowe, you don't have a cross appeal, so you don't have rebuttal.
I know, Your Honor, but I was cut off before I could get to that. I had a discussion on 2.6, and then the court redirected me to the breach of contract claim. Thank you, Your Honor.
Thank you. Thank you both.
Thank you.
Last, we have Nadeem versus Gotti.
Hi, good afternoon, Your Honor. I wanted to point out, it's Edward Steinberg on behalf of the respondent. It's our position that the decision of the court dated August 30th, 2019 should be reversed because the respondent in the first instance did not meet its burden of establishing no triable issue of fact as to the appellant's serious injury. The report submitted by the respondents in their own defendant medical exams found significant limitations in range of motion loss to the extent of 60 degrees at page 62 of the record. First Department and Curate and Lewis have held that findings of that sort by a movement on threshold in and of itself would establish a question of fact. Furthermore, and maybe most importantly, the exam of Dr. Sharma, the defendant doctor, and Dr. Elfbein, another defendant doctor, were conducted on the same day, and they themselves, between them, have inconsistent findings from the exams. Again, proof that they have not established a clear burden of meeting that plaintiff has no serious injury since their own doctors are inconsistent with themselves. Both doctors failed to opine on causation in any of their reports. They failed to review or comment on any records other than a legal pleading. And their statement that the findings are subjective, in and of itself, the court has found in Moriera and Torres, are not enough to establish a lack of serious injury. The radiology report, again, is consistent in that it also finds a one-level disc pathology, finds no other levels on a 28-year-old plaintiff, and yet uses words like degenerative in trying to create some issue that there's no serious injury causation.
Is there anything that refutes Dr. Tamflet's degenerative argument?
Yes, both the radiology report that was certified by the radiology exam that was submitted, as well as the certification by the examining doctor, both reviewed the films and commented that there are no degenerative findings. In fact, our report of Dr. Simons, who was the treating facility's doctor at the time the client was seen went on to say specifically at page 216 of the record that, and 214, excuse me, that there is no evidence of any degenerative changes on the report. Finally, should the court even feel that the movement in the motion, the respondent, had met their burden, plaintiff has established by convincing evidence that certified records of the treaters, certified records of the radiology, all established issues of fact of causally related injuries of a 28-year-old who had range of motion loss within 30 days of the accident. And again, just lastly, our client at his deposition at 124 and 125 of the record gave qualitative limitations, as well as Dr. Simon's finding quantitative limitations at his own examination. That's all I have, Your Honor.
Thank you, Mr. Steinberg.
Thank you again. Be safe and hope everyone's well.
Thank you. This concludes oral arguments at the Appellate Division, First Department. Good evening.